this new story she was going to give, there wouldn't be any reason for the police to accept it. After all, she had already lied to the grand jury to point the finger at Adam. So instead of the truth, she told a lie of a brutal killing where she was also a victim. But because there cannot be any corroboration for the lie itself, Kayla intermingled some of the truth of how she and Adam covered up Harmony's death. The lie itself cannot be corroborated, but there would be corroboration in the truth of the cover-up. Because Kayla's new story was not true of how Harmony died, she lacked real memories to draw from, and the details did not fit. Both the details she provided and the ones she did not provide. And it is in those details, details based on a lie, that begin to reveal the lie still being told by Kayla. At first, Kayla's new story for the police, when she gave a proffer on June 3rd of 2022, her new story was that it was the middle of the night, 2 or 3 a.m. Harmony had been having trouble controlling her bodily functions while the family had been living out of the car, and Harmony went to the bathroom again. Adam responded by repeatedly punching Harmony, probably like 10 to 15 times. That story changed to Adam assaulting Harmony in the morning before they went to the clinic for their methadone. The story then continued by saying that Adam struck Harmony again after getting back in the car from the clinic. Then, as they drove to Burger King because Kayla wanted to get something to eat for her and the kids, the story expanded to Adam punching Harmony as he was driving into the Burger King parking lot. Kayla claimed to recall Adam commenting that the last strike was different. He thought he hurt Harmony. Kayla did tell the police that she put an arm up briefly to try and stop Adam, but to no avail. Adam drove up to the Burger King drive-thru. They ordered their food. Adam paid cash. The family got their food and drove back to the Colonial Village apartments with Harmony moaning in the back. That's her story. And when asked, Kayla claimed that she fed the kids. She told the police that she went up to her friend Anthony Bodero's residence to get some drugs for she and Adam to use, leaving Adam alone in the car with Declan, Seamus, and Harmony. This whole entire story was not true. Excuse me. One of the things that you'll see that reveals her story about punching to be a lie is that she is unable to describe a true scene. She does not describe 2-year-old Seamus crying as his sister beside him is being struck. She does not describe the baby screaming as violence and chaos break out around him. She does not describe trying to soothe or quiet the children. Nor does she describe Adam reacting at all to what would have been a cacophony of screaming and crying had all that punching been true. She does not describe trying to hide a broken child from the Burger King cashier or any concern on Adam's part that Harmony might be seen by the cashier or the camera. She does not describe Harmony as she feeds, piece by piece, food to Seamus, who is next to her in the back seat of the car. She does not describe seeking help from her friend she got drugs from. She doesn't describe any concern by her friend, Anthony Bodero, that she seems upset. And please keep close attention to Kayla's various descriptions of the car breaking down, where she claims that she and Adam first discovered that Harmony is dead. Kayla told the police that with Harmony in what would have been a critical, perhaps fatal condition in the back seat, the family decided to drive away from their corner in the back of the Colonial Village apartments. Yet, Kayla did not remember where they were going. Then the car broke down at the intersection of Webster and Elm, and they discover Harmony's dead body in the back seat. Kayla talked about waving, honking, agitated drivers behind them around the car as Adam manhandles a dead child in the back seat into a duffel bag. And no one notices. Their car did break down on December 7th at the intersection of Webster and Elm. That is not in question here. And the family did walk back to Bodero's. But Harmony's body was already in the duffel bag, in the trunk, from when they discovered her death in the early hours of the night before. Yesterday, before we broke, the court gave you a partial set of instructions on how you are to go about deciding this case. Among them was an instruction on assessing the credibility of witnesses. It is up to you to determine the credibility of witnesses. But the judge did suggest an illustrative list of factors to consider in making that determination. One factor is whether what the witness said appeared reasonable. In discerning this, details matter. The details that are given and the details that are not. Is the witness pulling from a well of true memory or just making it up? Another factor the court has offered for your consideration is whether what the witness said is consistent with other evidence in the case. And that leads me to some of the science that was used in this case. Kayla also described Adam cleaning up blood spilled by Harmony with a kerchief. That lie was exposed by a special test that can reveal blood traces, even blood that was supposedly cleaned up. Luckily for the police, they were able to locate the broken down Sebring 2 years later. They're able to bring it to their lot at the police station, and they were able to search and test it with a special test that could detect invisible blood, blood that cannot be seen with the naked eye. No traces of blood, including on the back passenger seat where Kayla said Harmony bled and Adam cleaned it up. In offering guidance in assessing witness credibility, another common sense factor offered by the court is whether the witness had a bias or motive to lie. There will be time during Kayla's testimony, during direct and cross, to explore the changes, the inconsistencies, and details within her story, both those that are there and those that are not. And you just heard about the science to also assist you in evaluating Kayla's claims. But here, what follows is an example of Kayla's motive to lie at play, of Kayla taking something true and twisting it to point the finger at Adam, yet hide her own involvement. In telling the police how Harmony's body was finally removed from their lives, Kayla described an incredibly disturbing treatment of Harmony's body. Her remains in the refrigerator before being placed in the shower, under hot water, washing away the fluids. Kayla at first said it was all Adam, and he wouldn't even let her in the bathroom. But she slipped up, and fortunately the interviewers caught it. They caught the slip and they probed. Kayla had to admit that she was part of it too. She cut off Harmony's hoodie in the shower and she and Adam bagged up Harmony's clothes. And when that was done, Kayla and Adam put her remains in another bag, with Kayla helping Adam to zip that bag up. You will hear that after Adam and Kayla permanently hid Harmony's remains, that their relationship became more frayed. Adam struggled with the loss of Harmony and his mental health suffering. Adam and Kayla separated briefly. That was in the spring of 2020 before reconciling. But Adam continued to spiral, and a year later was arrested after another episode. He went to rehab, then stayed at a sober house before going to Maine with Kelsey Small, which was where he was in December of 2021 when Kayla told him to return to New Hampshire and help her deal with the police. Joined with the murder and related charges is a second-degree assault charge. That allegation is that Adam knowingly caused bodily injury to Harmony in July of 2019 by striking her in the face with a fist. Harmony did get a black eye during the summer of 2019, and no question about it, Adam did react when he saw Harmony trying to smother her brother, jerking her away to stop her, but that is not what caused the black eye. On July 22nd of 2019, Kevin Montgomery, Adam's uncle, came up from Florida to the house. He saw Harmony's black eye, prompting a conversation about her. During this conversation, Adam told Kevin about a time when he walked in to find Harmony smothering then 5-month-old Declan. Harmony had her hand wrapped around his mouth, causing him to turn blue. Adam pushed Harmony away while checking on Declan. Then, a week later, upon returning to Florida, I believe it was July 29th, Kevin made a report to New Hampshire DCYF, and he told DCYF that Adam gave Harmony a black eye, conflating what Adam had said. A veteran caseworker, Dimitrios Saros, responded that very same day, the 29th, to investigate. Though the encounter was brief, he did see Adam and Harmony outside the house getting into a car, and when he saw Harmony, he observed no concerns. He also followed up, paying another visit on August 7th. This time he did see a small red mark in Harmony's right eye and faded bruising under the eyelid. He spoke to Harmony alone, asked probing questions to find out what may or may not have happened, and then, after doing his job, left the visit satisfied that there was no substantiated evidence of abuse. I am getting ready to step down, but before I do, there is just one more instruction I need to discuss. The court has instructed you that you are to decide this case not on sympathy, but on the evidence and the evidence alone. This case involves the tragic and senseless death of Harmony, an innocent 5-year-old, and it triggers perfectly understandable, innate human emotions, and it would be inhuman not to feel them. But as was discussed during the jury selection process, and as you've been instructed by the court, you all have a difficult yet necessary task: deciding this case not on emotion, not on sympathy, but on the evidence. And after you have heard all the evidence, after you've heard all the evidence in this case and apply the facts to the law, you will know that Adam did not murder his daughter or engage in witness tampering with Kayla. Kayla was an equal participant in the cover-up. She alone knows how Harmony died, and she won't tell. At this trial's conclusion, We will ask you to follow the evidence you have heard and find Adam not guilty of murdering his daughter, witness tampering with Kayla, and second-degree assault.
All right, ladies and gentlemen, you've now heard opening statements. As I told you when I gave you my preliminary instructions, we would generally be taking a mid-morning and mid-afternoon break, and I do look for natural breaking points in a trial to do that. I think this is one of them. So what we're going to do is we're going to take a 15-minute break now, so use the restroom, have a drink of water, and we'll come back in 15 minutes and begin the evidence. All right, all rise for the jurors, please. Maybe seated, counsel, approach for just a minute.
Bundy. They're the worst of the worst.
It's Adam Montgomery.
Yeah, it is.
Even a tenth of what the state says is true. This guy is the most despicable person on the face of the earth. Stay with us.
He was seeing someone who was identifying as a male.
Ezra McCandless had changed her name from Monica to Ezra. She is standing trial for stabbing one of her lovers to death.
Was this murder?
She fought to survive.
How many stab wounds are too much for self-defense?
Her wounds could have been self-inflicted.
This case is about a twisted form of love.
You budget. You pay bills.
Yet somehow women like you, like me,
Are 80% more likely than men to live in poverty in retirement.
You can see it?
You can be seated. Thank you. What?
He's taking a comfort break. Yes, sir.
Attorney Smith, Attorney Brooks, ready? All right, we'll bring the jurors in now. Bring them in. Please rise for the jury.
All rise for the jury.
All right, I'll ask the jurors to please remain standing. Everyone else, you may be seated.
Members of the jury, I'm going to swear you in now. So if you could please raise your right hands, and at the conclusion of the oath, if you would please say, "I will." You so solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charges or charges against the defendant, so help you God. Amen. Thank you. Members of the jury, you can be seated. I'm going to now read the charges to you in this matter. There's 5 charges. The first is charge ID 193-7947C. This states that Adam Montgomery of Manchester, New Hampshire, in the state of New Hampshire, between approximately July 1st and July 22nd, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree assault, in that Adam Montgomery did knowingly cause bodily injury to H.M., date of birth 6/7/2014, a child under the age of 13, by striking her in the face. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge in this matter is charge ID 202-7112C, and this states that Adam Montgomery of Manchester in the state of New Hampshire, on or about December 7th, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree murder, in that Adam Montgomery did recklessly cause the death of Harmony Montgomery, date of birth 6/7/2014, a person under 13 years of age, under circumstances manifesting an extreme indifference to the value of human life, by repeatedly striking Harmony Montgomery on the head with a closed fist. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge is charge ID 202-7113C, and this states that Adam Montgomery of Manchester in the state of New Hampshire, between approximately December 7th, 2019 and March 4th, 2020, at Manchester in the county of Hillsborough aforesaid, did commit the crime of falsifying physical evidence, in that Adam Montgomery, believing that an official proceeding, as defined in RSA 641:1, Roman numeral 2, or an investigation was pending or about to be instituted, did purposely alter, destroy, conceal, or remove the body of Harmony Montgomery with a purpose to impair its verity or availability in such proceeding or investigation. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge in this matter is charge ID 202-7114C, and this states that Adam Montgomery of Manchester, New Hampshire, at Manchester, between December 7th, 2019 and March 4th, 2020, did commit the offense of abuse of a corpse, in that the defendant did purposely and unlawfully removed, concealed, or destroyed the corpse of Harmony Montgomery or any part thereof. And this is against the peace and dignity of the state. And then the last charge is charge ID 202-7115C, and this states that Adam Montgomery of Manchester in the state of New Hampshire between approximately December 7th, 2019 and January 4th, 2022, at Manchester in the county of Hillsborough aforesaid, did commit the crime of tampering with witnesses and informants, in that Adam Montgomery, believing that an official proceeding as defined in RSA 641:1, Roman numeral 2, or investigation was pending or about to be instituted, did purposely attempt to induce or otherwise cause Kayla Montgomery to testify or inform falsely. Said acts being contrary to the form of the statute in such case made and provided and against the peace and dignity of the state. Ladies and gentlemen of the jury, the defendant, Adam Montgomery, has been arraigned on these charges and he has pleaded not guilty, and of this he puts himself upon his country for trial, which country you are. Assistant Attorneys General Benjamin Agati and Christopher Knowles for the state have joined the issue, and you are to say by your verdict if the defendant, Adam Montgomery, is guilty of the crimes whereof he stands indicted or not guilty. Hearken to the evidence. Thank you.
Members of the jury, shortly you will hear opening statements by counsel. Before that, I'm going to give you some general instructions as to the law that applies to this case and some other matters which will give you some guidance as you consider the evidence in this case. After you have heard the evidence and you have heard closing arguments, you will hear further instructions from the court, and then you will retire to the jury deliberation room to decide your verdict. You should consider all of the instructions I give you, both now and at the end of the case as a whole, and not single out one particular instruction as stating the law. You will also have written copies of my instructions with you in the jury deliberation room. So, ladies and gentlemen, this is not a memory test. What I ask of you now is just listen carefully to the instructions that I give to you. You will have as many copies as you like in the deliberation room when it comes to decide your verdict. So you will have written copies of both the instructions that I give you now as well as the ones that I give you at the end of the case as a whole. And every juror can have one available to them. So please just listen carefully now as I give you these instructions. The function of the court and the jury. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before deciding your verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I am about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law you must follow in reaching your verdict. It is up to you to decide the facts. You must decide the facts solely from the evidence in this trial. You must apply the law given to you in these instructions to the facts and in this way reach a fair and just verdict. You should decide the facts without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I explain it to you. The evidence in the case. In deciding this case, you should consider only the evidence in the case. The evidence consists of testimony under oath of the witnesses, exhibits which have been admitted into evidence, facts of which I take judicial notice, and stipulations of certain facts. During the trial, the lawyers may make objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustain an objection or exclude any evidence, you must not guess as to what the answer or evidence would have been. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. A judge is required to be neutral, and I am in fact neutral. If during this trial or at any point during these proceedings you believe that I have expressed or suggested an opinion as to the facts in my rulings, you should ignore that belief. It is up to you alone to decide the facts. In short, you should consider only the legally admissible evidence in deciding this case, that is, the testimony of the witnesses, the exhibits, stipulations, and facts of which I took judicial notice. We talked earlier that there will be a view in this case, and I'll give you an instruction on the view later, but the view is also evidence in the case, but you'll hear an instruction on that in a little bit. The indictments are not evidence. The fact that the defendant has been arrested and indicted is not evidence of guilt. The indictments are simply a way of giving the defendant notice of the charges. The indictments are a formal way of accusing the defendant of a crime in order to bring the defendant to trial. You must not consider the indictments as evidence of guilt. Multiple indictments, one defendant. Each of the indictments against the defendant constitutes a separate offense. You must consider each indictment separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on one of the indictments should not influence your verdict with respect to the other indictments. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge. You should base your verdict only on the evidence and the law without considering the possible punishment. The presumption of innocence. As you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you, beyond a reasonable doubt, that the defendant is guilty of each and every element of the offenses with which he has been charged, and the defendant has no obligation whatsoever to prove his innocence in this matter, and that includes the right not to testify if he so chooses. You are not allowed to draw any unfavorable, adverse, or negative inference if the defendant does not take the stand in this matter. The jury's recollection controls. You will hear the lawyers discuss the facts and the law in their opening statements and closing arguments to you. These statements and arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Direct and circumstantial evidence. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony or statement of a person about what the person saw, heard, or did. Circumstantial evidence is indirect evidence, that is, proof of a chain of facts from which you could find that another fact exists, although it has not been proved directly. For example, if you look outside and see water droplets falling from the sky, that is direct evidence that it's raining. But if you look out the window at night and the ground is dry, and again the next morning and the ground is wet, that is indirect or circumstantial evidence that it rained during the night. By circumstantial evidence, I simply mean that you may infer the ultimate fact from another fact shown. You should feel free to reach reasonable conclusions from proven facts. Conversely, you may not reach conclusions based on facts that have not been proved. In the rain example, wet ground alone may support an inference that it rained during the night. But in the absence of additional evidence, it will not necessarily support inferences about how much rain fell or for how long a period of time. You should consider both kinds of evidence. You are permitted to give equal weight to both, but it is for you to decide how much weight to give any evidence, whether it be direct or circumstantial. However, to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other rational conclusions. This means that if from the circumstantial evidence it is rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. In determining whether all rational conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence, which includes all other circumstantial evidence and direct evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in direct evidence. In this situation, you, the jury, should resolve the conflict and must decide whether, based upon all of the evidence, the state has proved the defendant's guilt beyond a reasonable doubt. You should consider all of the direct and circumstantial evidence in the case, as well as any reasonable inferences you draw therefrom, in deciding whether the state has proved all of the elements of the crime beyond a reasonable doubt. The credibility of witnesses. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's attitude, behavior, and appearance on the stand, and the way the witness testifies. The witness's age, intelligence, and experience. The witness's opportunity and ability to see or hear the things about which the witness testifies. The accuracy of the witness's memory. Any motive of the witness not to tell the truth. Any interest that a witness has in the outcome of the case. Any bias of the witness, or friendship or animosity the witness may have for or against any of the other people in the case. The consistency or inconsistency of the witness's testimony. Whether or not what the witness says appears reasonable or unreasonable. Whether what the witness says is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witness to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. These principles apply to all witnesses, whether they are ordinary citizens, police officers, experts, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. The weight to be given to the evidence should be determined by the quality of the evidence, not the quantity. It is not the number of witnesses or the quantity of the evidence, but the quality of the evidence that is important. The judge decides what is admissible. Testimony, writing, objects, and other things presented during the trial are evidence only if the judge accepts them as evidence. Throughout the trial, I may rule on whether certain evidence was admissible or not admissible. These are legal decisions which do not concern you, because only the judge is permitted to decide legal questions. I may make 3 types of legal decisions with regard to the evidence. First, I may stop some information from being presented at all. You are not to imagine what that information might have been had I allowed it to be presented. Second, I may rule that some information was not admissible after it was presented to you. You are to ignore this information and not use it as evidence. Finally, I may allow some information to be entered as evidence after hearing objections by one of the lawyers. You are not to give such evidence any special importance as a result of my ruling. It is not my duty, and I do not try to determine whether the evidence is important when I make my rulings. The burden of proof and reasonable doubt. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss with you how convinced one way or the other you must be, and this is referred to as the burden of proof. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. As I told you earlier, the defendant enters the courtroom as an innocent person, and you must consider him to be an innocent person until the state convinces you, beyond a reasonable doubt, that he is guilty of every element of the alleged offense. If after all of the evidence and arguments you have a reasonable doubt as to the defendant having committed any one or more elements of the offense, then you must find him not guilty. Now finally, ladies and gentlemen, a reasonable doubt is what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the charged offense beyond a reasonable doubt, you should find the defendant guilty. With respect to the final instructions regarding the offenses, I will wait until the end of the trial and after closing arguments and discuss it with you at that time. So as I said, I will give you another set of instructions after closing arguments at the end of this case. You will have all of these instructions with you in the deliberation room when it comes time to decide your verdict. As I said to you earlier, there's a form of this instruction that I'm about to give you. We call it the communication instruction that I'll give you. I've given you some of it before, and I'll continue to give it throughout the trial. Please listen very carefully. Do not discuss the case at all, not with the other members of the jury or with anyone else, until jury deliberations start at the end of the trial after all of the evidence and final arguments have been presented. Please keep an open mind until you have heard all of the evidence in the case. During the course of trial, please take care to avoid any contact with any persons involved in the case, the lawyers, the witnesses, and the parties. So I remind you, ladies and gentlemen, as you come in and out of the courthouse, you may see the lawyers or other people involved in the case. They have been instructed that they are not to communicate with you, so they are not being rude if they don't acknowledge your presence or smile at you or say hello as you may pass them in the hallways. But you must, they are required to avoid any contact with you, and you are required to avoid any contact with them. So no contact with anyone involved in the case, please. Also, please be sure to avoid any television, radio, online, or newspaper coverage of this case. I anticipate that there will be media coverage of this case. As I indicated earlier, you know that there are cameras in the courtroom. They have been instructed that they are not to take pictures of the jurors in the case, but I expect that there will be media coverage. You are instructed that you must not read any articles or view any media coverage on television, online, or elsewhere. So avoid your local papers. Have somebody pull the international section if you want, but don't watch any media coverage of the case, okay? You are instructed to turn off any notification or banners that come through your smartphone, computers, smartwatches, or other devices, okay? Finally, do not conduct any research or investigation of your own. You must render your verdict based solely on the evidence submitted at trial. So don't look up the law. That will be given to you in the court's instructions. Don't drive by any locations. Don't look up any names. Don't look anybody up on social media. It is critically important that your verdict in this case is based exclusively on the evidence that's presented at trial. Our trial day will generally go from 9 a.m. to 4 p.m. We will also generally take a mid-morning and mid-afternoon break. I try to look at sort of natural break points in the case to determine when those breaks happen. But generally we'll have a mid-afternoon, mid-morning break, and we'll also have a lunch break. The court has asked you to put your cell phones in a box in the jury deliberation room. Please make sure they are silenced or turned off altogether. As I said to you, you will be permitted to check your phones when you are on break. However, you are not to look at any news reporting or media coverage of this case, as I have already told you. Additionally, you are not permitted to take notes of any kind, not on paper nor on your phones. The reason for this is that it is important that your recollection of the evidence is what controls. Sometimes, if notes are taken, they can be given undue weight, and it's important that when it comes time to deliberate, you are using your individual and collective memories about the evidence, and one note or one written recollection doesn't control. You should also be aware that there will be no transcript available to you when it comes time to deliberate. So although we have our excellent court monitors here and there's an audio recording, that is not available to the jurors, and there will be no transcript. So your individual and collective recollection is what will control as you go into the deliberations. Therefore, please listen carefully to the evidence as it is presented. If during the course of this trial you have any questions or problems, you become thirsty or need anything else, just get the court officer's attention, either of our court officers or my attention, so that we can assist you. If at any time during the trial you cannot hear, please raise your hand so that I can ask the witness or the lawyers to speak up. That goes as well for any monitors. If you cannot see, please do let us know. It is important that you are viewing and listening to all of the evidence as it's presented. So, ladies and gentlemen, it is now 20 of. I had indicated to you earlier that I thought we would go right into opening statements, but based on what I anticipate the length of the opening statements will be, I think that would hold your lunch off for quite a long time. So, after speaking with the lawyers, I think what we're going to do is we'll take an early lunch break. So we're going to break now. Please come back at in 1 hour, so 20 to 1. And then we'll move directly into opening statements. So don't talk about the case, not with each other, not with anybody else. Don't look up any media, don't do any independent research, and I will see you in an hour after lunch. Thank you so much, ladies and gentlemen. All rise for the jurors. Be seated. Do we have anything preliminary, or do you want to just come back at 12:30, or what would you like to do?
Just thinking, Your Honor, with regards to the arrangements for the bus. I'm trying to figure out what the time is and what we can do hopefully with them to shift through the times back. So maybe if we could approach on that.
Sure.
Up a story about being the victim of a racist anti-gay attack in downtown Chicago in 2019 and lying to police about it. Smollett was sentenced to 150 days in jail plus probation and a fine. Smollett's lawyers had argued a deal with Cook County State's Attorney Kim Foxx meant he could no longer be prosecuted. In a 2-to-1
I'm just going to show them
This is Exhibit N, and it's a photocopy, but this is the email you sent to Detective Kimball with one attachment on May 30th, 2019 at, I can't tell if it's 3:23 or 5:23, but
it's 5:23 p.m. It looks like.
Yeah, but it was that date.
Or it could be 3:23. You're right. It's kind of, but it was definitely that date.
Okay. And the attachment was something called Case Details Search After 5/23/2019, correct?
Yes. Let me explain if you like.
Sure, but let me first identify this as Exhibit CC, correct?
Yes, CC.
All right. So would you explain the purpose of preparing this document?
Yeah, this is an excerpt, I think, from an overall PDF. When I do a Burla data extraction, Burla has a tool where you can create a PDF case report right away. And it's that enormous PDF that the state's attorney was asking me about earlier, that's so many, over 1,000 pages. But it contains all the data that's extracted from the vehicle. And as part of our policy, once I complete the extraction, I usually will email that PDF report to whoever the investigating officer is so that they have that data immediately. Because a lot of times these are done during active investigations and they're looking for this information to find leads to follow in their investigation. So immediately when the extraction's done, I create the PDF, I email it out.
And so you're talking about there's a 1,000-page report, right?
It could be that big, yes. I don't know the number of pages of this report, but I'm sure it's quite large.
And it's all data. A lot of it's raw data, correct?
Well, it's data that's interpreted into plain English by the software, but it is the raw data as having not been gone through or by investigative eyes.
Well, just like the map report that we just saw that you prepared for the state,
yes.
This is a summary of some of the data in that 1,000 pages.
Correct. It's a summary of some of that data.
All right. So I'm just going to go through it with you. So
sure.
Up at the top, it mentions the year and model and the VIN number of the vehicle, correct?
Yes, correct.
Were you made aware during your conversations, you said it was a high priority case, correct?
Yes, it was.
So you knew that it had to do with the disappearance of a woman by the name of Jennifer Doulos that the police were investigating, right?
I was aware of that, yes.
Okay. And you were also aware that this was her vehicle, correct?
Yes. Obviously, the evidence can't be submitted to me without a search warrant. And before I do my examination, I always read the search warrant, which gives me a lot of information about the case, but it helps me know what type of data I'm looking for.
Obviously. Okay. So I'm just going to ask you, there's a section here, and I'm going to zoom out a little just so that it all fits on one page. And I'll move it down, but would you indicate for the jury what the call logs here show?
Yeah, call logs are basically, they come from the cell phone. When the cell phone is connected to the system via Bluetooth, the system immediately downloads, like I had testified to earlier, immediately downloads data from your cell phone relating to phone calls, including contacts and phone call history. So the call logs are phone call history downloaded by the infotainment system from the cell phone when it's connected.
And are these times local time or UTC time that are included in your report?
Well, if you look at the second column, it says timestamp, type, and it says local. So this device displayed the time in local time, not in UTC.
The next column talks about call type, outgoing versus missed, correct?
Correct.
And then the next is phone numbers.
Yes.
Right? And then the next column are contact names. Where would those names have come from? Well, let me ask it a different way. Are these the names that the holder of this phone, that is the owner of this particular phone, would have punched into their phone as an identification to if they were known recipients or senders, or does the system itself create that?
Those names come from the contact list in the phone. Most everybody has a cell phone, right? You have a list of contacts, and you can go to the contact you want to call and push it in. The contact list is downloaded along with the cell phone data when the connection is made. And the system, when a phone call is made, if it recognizes that number as one of your contacts, it's going to display that contact name along with that call. So when you see those names on there, Gloria Farber, Dwayne Lavold, those are from the contact list in that phone.
Now, you did not have the phone in question here, did you?
I did not.
So the device identifier, is this what you testified to on direct, would be the Bluetooth identifier, or would that be the serial number of the phone itself? The MAC number, I think you referred to.
It's the Bluetooth MAC address is what Burla tends to use as their device identifier. And the reason I shouldn't speak for Burla, but I believe the reason they use that is all these connections are made via Bluetooth, so it's a unique piece of data that's readily available in the extraction.
Is it called MAC because it's an Apple
No,
device, just MAC, or what is it?
just MAC.
And do we know what that stands for? Do you know what that stands for?
I'd have to look it up. I don't recall.
Right. But it's an abbreviation for something.
Yes, it's similar to an IP address. It's a unique address for each device in order to make a connection through Bluetooth.
Would you have made a determination that this device identifier was connected to the, or came back to the device registered to Jennifer Doolittle?
I don't know who this device is registered to. I know the date and time it was first paired to this device, and I know that the last date and time it was paired to this device. It's a device that was just called iPhone. So I don't have any ownership authentication to it within this data extraction.
But just in looking at the contact names, there was a Dr. Roy Geronimus who was called at 7:54 a.m. outgoing from this device while paired to this Chevrolet, correct?
Well, it's correct that there was an outgoing call made from that cell phone to a Dr. Roy Geronimus at 7:41 a.m. There's no data here to tell me whether or not that phone call occurred from within the vehicle. Some systems record that phone call made within vehicle. This system does not. That phone call could have been made outside the vehicle, and then when the device connected, it downloaded phone call history, and so the data's in there. But it doesn't tell me whether or not it was made from the car or from outside the car. I don't know.
Well, and the next call is, I guess these are in the next call earlier, rather, the evening before, May 23rd, was to somebody named Caroline Luft. You see that?
I do.
And then there was, you mentioned the other two people, one being Gloria Farber and one being Dwayne Lavold, correct?
Correct.
So if one were to go through the phone records of an individual, determine whether these calls in fact were occurred, one could match up that phone, so-called iPhone, to the particular device if there were phone records to do that, right?
Objection. Cause for speculation outside the scope about phone records.
Well, this witness has not testified concerning phone records, or basically those records generated by the phone company. So the question is, would the information contained on the call logs also show up on phone records generated by the company? That's the question, correct?
Yeah.
Overruled.
I think you answered yes.
Yes, I believe it would.
Okay. Now, the next column here, you have a box here called events. Are these the times that, when you say that the device paired to the specific Chevrolet Suburban on May 24th, 2019, according to this report.
Yeah, if you look at the bottom one on this report, the date on the left shows 5/24/2019, 2:56:32 p.m. That's local time. The event is identified as a device, and the action is identified as a device connection. So it's reporting a device connection of the unique identifier with that Bluetooth MAC address, 5C09, et cetera, was connected at that time.
And I know if you go to the event identifier, this MAC number that you identified that begins 5C0, et cetera, see
Right.
that?
That number is unique to each individual cell phone.
Is that the same identifier as shown under the call logs in the previous box on that same page?
5C09, C184. Yes, it is.
So can we conclude from this events box that the specific device, the one that either missed or sent phone calls in call logs box, connected to the Chevrolet Suburban at 2:56 and 32 seconds p.m. on May 24th, 2019?
Yes, that's correct.
I realize, Your Honor, there are 3 copies of the same document. I did make copies after when I stapled them, so I can give a copy to counsel if I may.
Yes.
Is it just one page?
Yeah.
You want to take the other one off?
Yeah. Now, if a vehicle has been paired with a, which way does it go? Does the phone pair with the vehicle through Bluetooth, or does the Bluetooth in the vehicle pair with the phone? Which way does that work?
Both. I mean, the two devices have to be set into pairing mode together and be within range of each other in order to pair them. So it's a very deliberate act.
So in other words, one has to, it's not just by accident. You can't be driving down the street and accidentally pair with a total stranger's vehicle's Bluetooth, correct?
Correct.
And the device MAC number that you testified to remains the same as long as you own that. It remains the same for that device, correct?
For that device.
If you get a new device, you have to pair it all over again because there'll be a different MAC number, right?
Yes, that's correct.
And each car has a different infotainment center system that has its own unique identifier as well, correct?
That's correct.
And once you've paired your device to a vehicle, will it stay there unless you erase it?
Yes, I believe it will. It doesn't, that list is pretty consistent. What it usually records is the initial date of the pairing and then the last date that it was connected at. Every time you connect it, it changes that last date of connection to the current date. So you don't know every time that it connected, you know the initial time and the last time.
Well, for example, if I were to pair to a rental car and then I forget to delete that, would that my pairing remain there? So the next time I go to that rental company, will that pair again?
Yes, I believe it would.
So it would be, I mean, this is not really
a vehicle.
So just for our edification, so it'd be good to delete it on your own. You can actually delete the Bluetooth pairing from a vehicle if you want to, right?
Most of them allow that in the user interface.
Okay. And you did testify that as new data is entered in, older data is deleted, correct?
What I said was, if data is marked as deleted by the system, as new data is recorded, that deleted data may become overwritten and then it's no longer accessible to us.
Well, for example, were you able to retrieve any earlier phone calls that aren't in this report from the infotainment center, from the Bluetooth connection to that device?
I believe there's a lot of phone calls in the full report of this extraction, but they don't relate to the time frame of interest.
That was what I was going to. So you were asked in this report by the detective to only limit it to the May 23rd to May 24th period, correct?
Yeah, for their investigation at the time, they were interested in anything that occurred around the time of Mrs. Doulos' disappearance.
Now, you were asked some questions about Bluetooth distance. Do you remember those questions?
I do.
Does it matter whether a window or a door to a vehicle is open or closed, what the distance is going to be to the from the device to the vehicle itself?
In my experience, no. It'll go through a closed door or window.
And the range you said is what? How far away can you be before?
I don't have a scientific answer to this. I mean, I have a personal analogy.
What's your analogy?
One time I was in the tire shop getting new tires, and my wife called me, and I'm sitting in the waiting room talking to my wife, and the mechanic comes in and says, "Hey, we can hear your call on the phone's radio." And I had to be a good 50 feet away from where the car was being worked on. So it's a pretty good range.
50 feet.
Yeah, I bet I was.
And was there a wall or glass between you as well?
A wall with a closed door, yes.
Okay. How long does the vehicle store the Bluetooth data?
In terms of the connected devices, I don't believe that gets marked for deletion unless someone manually goes in and deletes it.
So it can go back maybe years?
I believe so, yeah. In fact, I'm sure I've seen connected devices going back a few years, yeah.
Is that one of the reasons the report is 1,000 pages here?
Absolutely, yeah.
Okay.
There's a lot of data in these things. I mean, most of it is irrelevant to your investigation, but it's there and it's recovered, so.
And just like I asked you about the Ford, does the vehicle have to be turned on, or at least the power turned on, in order for the Bluetooth system to work with that vehicle?
Yes, it does. It's an electronic device. Without power, it can't do anything.
The phone itself, however, connects to let me re-ask this question. I want to understand this part. It's the phone receiving and sending phone calls through the car system? In other words, is the car connecting to a cell tower, or is it the phone itself?
Well, the car is capable of connecting to a cell tower if it has cellular service. You would have to buy cellular service for the car, though. I mean, it's the cell phone primarily that's connecting. The cell phone is connected to the cellular network and to the infotainment system through Bluetooth. But the actual connection is being made in the cell phone.
So when it comes to, were you able to tell whether in this particular case and in this report that the Bluetooth connection was more just as like a wireless speakers? In other words, it was a hands-free availability that would connect so you could hear things like you just explained.
Correct. That's exactly what it is. It's for the purpose of hands-free driving. But the phone is what's doing making the actual connection to the outside phone.
But other than that, the cell phone itself would have to connect to cell tower service, correct?
Yes.
Did this vehicle, when you examined it, have a hotspot or an internal cellular ability so that you could make calls from the car rather than use your own cell data?
I do not believe it did. No. Okay. A cell phone would have had to have been present to make a call.
Can I just have a moment, Your Honor?
Yes.
One final question. After you sent this material to Detective Kimball, did you speak to him to help explain any of this data to him?
I can't recall speaking. I mean, I can't say for sure that I didn't. It was 5 years ago, but I don't recall having that conversation.
Okay. Thank you. I don't have any further questions.
Just briefly, if I can. Sir, just a couple more questions. Thank
Sure.
you. Just a couple questions on the on Bluetooth and the capabilities. Attorney Shohern asked you a couple questions about the location and whether the door had to be open. Do you recall that line of questions?
I do.
Right. And you told the story about at the car wash?
The tire shop.
The tire shop. There you go, tire shop. And there was a wall between you and the car?
Yes, I was in a waiting room. The car was in the garage getting new tires put on it.
What about if there were trees in between a phone device and a vehicle that was running? Would the phone be able to connect to the Bluetooth of the car?
I mean, it's not like I've done any scientific studies on it, but in my personal experience, I would say the trees would not affect it.
Bushes?
Probably not.
Okay, people walking?
No.
Okay. If the phone was just around and in an area close to the...
If it's within a close enough distance to the system and both the phone and the system are powered on, it's going to connect.
And counsel asked you about deleting the pairing of the phone off of the vehicle. Do you recall that line of questioning?
I do, yeah.
And is that something a person can manually do?
Yeah. I think I've done that before on some of my old cars. You can go in and you can cancel your pairing and then repair it if you want to, or...
Can you also cancel the location services of the infotainment center?
I'm not aware of... I don't know how to answer that. I'm not aware of any way that you can do that, but without researching it, I can't say with certainty.
And a couple of questions, if we can. If I may just approach the clerk, Your Honor. It's 129. Sir, briefly, Attorney Shohern asked you about the movement of the vehicle, particularly Sturbridge Hill.
Yes, I remember.
Okay. And you indicated there were 3 data points that you found during that time period, 9:53 and 12:30, correct?
Mm-hmm.
Okay. Now, with respect to those 3 data points, did the vehicle move from that spot at those 3 specific times?
It did not appear to. Those 3 specific data points are right on top of each other. I mean, there's no separation in those circles. So if the vehicle moved at that time, it was parked again in the exact same location. I mean, quite precisely.
Okay. And if you look at page 1 of that report, you actually have the vehicle moving at Jefferson Crossing in a very small spot. Is
Yes.
that correct? So that would be the show of the movement from a vehicle from one place to another.
Correct.
And with respect to Sturbridge Hill, though, the spots remain in the exact same spot?
Correct.
And
That's just
this-
one single data point.
One day. And this road here, up and down, you titled that Sturbridge Hill Road. Is that the main road? And then and my next question would just follow up, and then does that make this the driveway?
Yes, Sturbridge Hill is the road, and that line there that leads to the house is the driveway.
And the dot behind the house would be the vehicle.
Correct.
Oh, one last question, actually, I'm sorry. I just wanted to see if I could clarify on that same States 129. You indicated on cross-examination, the EST was just a typo. It's supposed to be EDT, is that correct?
Yeah, you know, sometimes I'm not the brightest bulb on the Christmas tree. I should have wrote EDT because it is summertime, so it would be Eastern Daylight Time.
But the times in the date reflected?
The time reflects a -4 hour correction, which is accurate for summertime or daily time.
It's just a typo. The times are not inaccurate.
The times are accurate. The EST is my stupid mistake.
I want to call it that. Thank you, sir. I have nothing further, Your Honor.
I just want to clarify on what you were just shown on Exhibit 129, if you would, if you look at that. There were three, I guess we call them event times listed at the top: 4:52, 5:05, oh, 4:52, 5:05, 5:09, and 5:10. Is that right?
Yes.
This diagram isn't showing that between those times the vehicle only moved. Like this blue line is not showing that it moved from the red dot to the green dot or the green dot to the red dot, does it?
Yeah, usually the blue line indicates the motion of the vehicle.
And it took, according to this, maybe 18 minutes to move, what, 6 feet, 10 feet?
Yeah, I mean, not all of the data is present, so we don't know exactly when it moved between those 2 points of data.
So, because I wanted to ask, there's been testimony in this case that this vehicle went to other addresses in Avon and Farmington during this very time that's indicated here. Do you have any data that shows that it was at another location?
All the data that I recovered is present in this document. So, and data that occurred at times that I did not recover from, I can't testify to. I don't know.
So I'm going to ask you, is it possible that what this is showing is that this vehicle started up at this location, traveled elsewhere, came back to this location at Jefferson Crossing, and maybe was turned on a second time?
It's hard for me to answer that because you're asking me to testify about data that I did not recover. So I can't really do that. Well, if I had those data points, I'd be happy to point it out to you, but I can only show you, I have these 2 data points. A blue line indicates usually that there's motion with Verla, but that's all I was able to recover.
So as far as you know, there's no data about this vehicle being at an address on Deer Cliff Road in Avon, correct? That you recovered?
Wasn't it driving along Deer Cliff in one of these points of data? I think that name Deer Cliff sounds familiar. I think it was.
Was that was on?
Go to the last data point of the day. Didn't it drive along Deer Cliff, or am I wrong? What's the last one on the second to last page?
Oh, okay. Yeah, it shows at.
Yeah, Deer Cliff Road. Right.
8 o'clock at night, driving on Deer Cliff Road, right?
Yeah, 8 o'clock at night.
Right. What about at on May 23rd?
I don't think I recovered it on Deer Cliff Road on May 23rd.
And was there any, what about 80 Mountain Spring Road? Was there any data recovered that this vehicle traveled to 80 Mountain Spring Road on the 23rd?
I don't recall any of that, no.
I have no further questions. Thank you, sir.
Nothing further.
Mr. Newth, you may step down. Thank you.
Thank you, Your Honor.
Your Honor, the state would call Detective Mike Clark. Yes, please. Thank you.
If you could please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
My name is Michael, M-I-C-H-A-E-L, last name Clark, C-L-A-R-K.
Sir, you may be seated.
Good afternoon, Detective.
Good afternoon.
By whom are you employed by?
I'm employed by the Fairfield Police Department,
And in what capacity?
currently in the capacity of police detective.
How long have you been a Fairfield Police Detective?
I've been a Fairfield Police Detective since 2016.
Are you assigned to a particular division or department within the Fairfield Police Department?
Yes, so I am assigned to the Detective Bureau, and I currently work in that function doing cyber investigations. I manage our cold case homicide investigations. I manage all of our digital investigative technology, as well as being a qualified forensic examiner, digital forensic examiner for the agency.
And what is a digital forensic examiner?
So a summary of what a digital forensic examiner would do. I assist with the initial acquisition of digital devices and digital data, and then the preservation of those devices and that data. Following proper legal procedure or sufficient search authority, I would conduct extraction of digital devices and the data contained within. And then I would work with an investigator to look through that data and determine whether there was anything, any evidence related to their case or any exculpatory information related to their case as well.
When you say digital data, what are, essentially, we're talking about computers and cell phones and other electronic devices, is that correct?
A digital device, yes, would be a cell phone or computer or tablet or something capable of storing digital data.
I'm going to direct your attention primarily to cell phones when I ask you these questions. Is that okay?
Yes.
Okay, could you just briefly maybe explain a little bit about your training and experience to become a digital forensic examiner, particularly with respect to cell phones?
Sure. So aside from being a police detective and having extensive training and experience in criminal investigations, I also have 3 certifications through Celebrite, which is one of the leading digital forensics companies in the world. Those certifications are as a physical operator, physical analyst, and also a certified mobile examiner. I've also been to the NCFI in Alabama, which is the Secret Service training facility for digital forensics. And I've taken multiple classes through the NCFI in cyber investigations. I also spent 2 years as a task force officer in the Federal Bureau of Investigation, doing cyber investigations there and attaining secret and top secret security clearance during my time, and 3 years in a digital forensics lab known as the TIU, which was sponsored by the Secret Service and focuses on, again, digital forensics. I have training through the FBI in the analysis of location data via cellular towers and digital devices, and also how to map those on a program to be able to view them. I also have training and experience in utilizing video editing software to make court-ready presentations or presentations for media dissemination, as well as having attended many different seminars and classes in continuing education in this career path.
Now, you mentioned the Technical Investigative Unit, TIU.
Yes.
Can you just briefly explain where is that located and what does it do?
Sure. So the TIU is a lab in Weston. It's manned by detectives, officers, different ranks of people that are all digital forensics individuals. And it's a lab where they can take a larger amount of digital devices from different places. They have access to different tools, and they'd be able to conduct extractions or analysis of other devices.
Were you a member of TIU?
I was.
Now, you mentioned a couple terms. I'm going to ask you to define them a little bit if you can. You just mentioned extraction. What does that mean?
Yeah, so I have a simple way to explain an extraction. So we mentioned digital devices being something like a phone, and phones contain digital data, so the data that's stored on those phones. So what an extraction does, I would utilize a tool or a program to be able to remove or copy the data, is a better term, to copy the data from a digital device and to move it to a different place where it's created, it creates this packet of data known as a zip file, and it would later allow me to parse that data to be able to view what was on the device.
What are some of the tools that you utilize to assist you in extracting the data?
Primarily, I utilize GrayKey, which is an extraction software, as well as Celebrite UFED for PC, which is also an extraction software.
As you're conducting the extraction of a cell phone, are you able to see it on a screen or, I guess, observe it as it gets downloaded or copied?
So as I'm conducting the extraction with just those programs as extraction tools, I'm able to see that the data is being extracted and how much time it's taken, but I can't see all the data that has been extracted until it's done and been parsed.
Does GrayKey extract the entire contents of the phone?
GrayKey will conduct the best extraction that it's able to based on several different factors, such as the make and model of the phone, the software on the phone, the chipset in the phone, and then the same thing for GrayKey as well, the software version on that. So it does a best level extraction, but generally it's not able to copy every bit of data off of that device.
Does the phone need to be connected to the internet for you to do the extraction?
No, it does not.
Do you take any steps to ensure that the phone that you are attempting to do an extraction on is not manipulated in any way?
Yes, so the primary initial step is putting the device in airplane mode. It's a term that we call network isolation. It just prevents the network from touching the device. That way the data can't be deleted or manipulated. And there are other things like Faraday bags that prevent data transmission. And then once it's paired with GrayKey, it'll also put it in airplane mode, again, to prevent it from being manipulated.
You also use the term parse the data. What does parse mean?
Sure. So once the data is extracted, it creates that packet I mentioned, so that zip file. And what parsing does is I use another program which is able to look into that data packet, and it's able to pull the data out of it and organize and categorize it in a manner that we're able to view it as it was intended to be viewed on the device. So an example of that, it would take all of the pictures and put them in a pictures category, and the locations and put them in a locations category, and videos and put them in the videos category. So when we look at the program, the user interface, I'm able to go and see, okay, what were all the pictures on that device or videos or locations.
What is the tool you utilize in order to parse the data from the extraction?
Generally always Physical Analyzer, which is a Celebrite program.
Is it fair to say that GrayKey assists you with the extraction and Celebrate assists you with the analyzing the data?
That depends on the device, but in most instances, that is what I use, yes.
As Celebrate analyzes the data, are you able to see it on a screen?
Yes.
And after it analyzes the data and creates a report, is that called a certain thing?
Yes, so after the data is open, I'll generate two separate reports. One would be a written report, and the other would be a digital report that would be turned over to the investigator, and that's called a UFED reader report.
A UFED reader report?
Yes.
The whole process of extracting the data and then utilizing the Celebrite to analyze it and create the UFED reader, did I get the terms right?
Yes.
Okay. Did that alter the data in any way?
No, it does not alter the data that's on the device already.
Does it provide a complete copy of the phone?
It provides a copy of the best copy it's able to. So it doesn't provide a complete copy bit by bit of the device if it's a file system extraction, which is what Gray Key uses, but it will copy the entire file system.
Does the information that it is able to get from the phone, is that a true copy of the phone, even if it doesn't have all the information at that time?
Yes.
How do you know that?
Well, we know it's an accurate copy because it's copying that file system data from that device. So we know that that it's pulling accurate data from there.
Do you need to have the password to the phone in order to access it using Gray Key?
Not necessarily, but it does help. It's useful to have. So we try our best to get it when possible.
If you were to take I guess the original data from a Gray Key extraction and apply a newer version of a Cellbrite analyst or analytic tool to that original data, would you be able to get more of that data?
I can't say we'd necessarily get more data, but at times there's data that's not viewable initially with certain software versions of Cellbrite Physical Analyzer. And as the companies learn that there are different items within the phone that they can parse out or find, newer versions will make things that weren't viewable at a certain time viewable at a later time.
Well, let me ask you about that. So you said viewable. So the first extraction, the data points come in a certain format, and the Cellbrite is able to do something to it so that you're able to view it and read it. Is that correct?
Yes.
So as technology changes, if you were able to utilize newer technology, would that then, I guess, make it the data, if there is stuff that wasn't originally able to view, you would then be able to see it. Is that correct?
Yes, that's correct.
Okay. Now, as you're actually doing the extraction and the Cellbrite and creating a copy of this data, are you reaching into the backup, the iClouds, and any of that technology?
It is possible to do. Generally with Gray Key, though, no.
How do you, well, what's a hash value?
So a hash value is something, it's a alphanumeric value that's assigned to a particular data set. And it's a unique identifying number similar to a serial number, whereas if that data set doesn't change, that hash value will always be the same. I utilize hash values to ensure that from the time I extract the value to the time I open the data set, that it's the same data set. And then I would apply a unique name to that data set to ensure that I always have the right one.
After you extract the data, parse it with Cellbrite and create a UFED, what are some of the things that you can see out of a phone? What are some of the contents that you can view?
Some of the contents we can view are things like pictures, messages, photos, videos, location data. And then there are also things that happen in the background of the device that we have access to that we can see, such as if the device was powered on or powered off or plugged or unplugged or turned in a certain orientation or not. So those are some of the things that we look at in the device.
You mentioned location data. What does location data look like on a UFED reader?
On a UFED reader, it would be, there would be a table on the bottom of it, and it would have your date, time, longitude, latitude, the type of GPS location data it was. And then there's also a map that shows up where you can click on a certain data set and it would generate a pin on a map and show you where that location was.
And by the way, when I say UFED reader, am I talking about the end result of the whole process of downloading and extracting the information from the phone?
Either physical analyzer or UFED reader would both do the same thing.
Does the location data utilize cell towers or GPS?
It can utilize both.
And can you filter the UFED reader to determine if there are location data points without the use of cell towers?
Yes, you can filter out cell towers if you wanted to and just have it show specifically GPS or photo data.
How does the GPS work on the phone if you take out the cell towers?
If you filter out the cell towers, it just won't show you where the cell tower was located that the device was utilizing. It'll just show you a GPS fix where the physical handset was located.
And is that similar to like a Waze or Google Map?
It could be.
When the location data is recorded, does that require a activity or a user interaction with the phone?
Not necessarily. No, it can happen as a system process.
So can the phone record a data point for a location if the phone is just in somebody's pocket?
Yes.
Does it have to be on?
Yes.
With respect to communication contained within the phone, are you able to access any kind of data points that are involved with communicating with other people in any way on the cell phone device through the use of Cellbrite and the UFED?
Yes.
If you could just explain a little bit about what you can get from a phone based on communication.
Sure. So kind of the two of the big categories we look at are phone calls. So if someone places or receives a phone call and voicemails, and then messages as well. So things like iMessages, short messaging service, SMS messages, Facebook messages. There are a lot of messaging apps as well that we look at.
You mentioned iMessage and SMS messages. What are those?
So iMessage would be a message between two users who have an iPhone and who have sufficient service to generate an iMessage. It utilizes Apple servers through data and transmits that message in that method. SMS is a short messaging service, which is kind of an older technology. And generally that'll happen between, say, an iPhone and an Android. So anyone who has an iPhone, if you see that green box instead of the blue box, you're sending an SMS or MMS message. And those go through the phone carrier as opposed to through Apple server.
Third-party messaging apps, are those separate from that iMessage, SMS messages?
They can be categorized under instant messages, but they are different. Yes, it'll show a different application handle that as opposed to an iMessage.
Would those be things like WhatsApp and Facebook?
Yes.
Are you, in the course of the extraction, are you able to look at any of those messages that are made through those third-party apps?
Yes.
Do you need to go directly to the Facebook company or WhatsApp company to get those, or can you just get them directly off the phone?
It depends, but often you can get them directly from the phone.
Are you able to determine based on the extraction whether or not the phone was, or what times the phone was turned on and turned off?
Yes, that is something that is recorded on the device.
What about the movement of the phone?
Yes, there are metrics that also determine that.
And all that can be viewed throughout the UFED reader?
Yes, as long as it's included in the report. So physical analyzer is what we create the report with, and as long as it's included, yes, you'd be able to view that.
And I'm going to draw your attention, sir, to May 26, 2019. Were you asked to extract and analyze a phone owned by Photostulos?
Yes, I was.
Who asked you to do that?
That was Detective Tom Patton.
Were you a certified digital forensic examiner in 2019?
Yes, I was.
Did you work for Fairfield Police Department?
Yes.
How did you get the call from Tom Patton to do the extraction?
I had known Tom in our time in the FBI. He was also a task force officer, and he also was certified through Cellbrite, so we had talked about digital forensics. He knew the tools and the abilities I had and reached out to me and asked if I could help him with a device.
Did Fairfield Police Department have Gray Key in 2019?
Yes.
And was Gray Key the tool that would allowed you to extract the information from Photostulos' phone?
Yes, that was what I used.
When did you receive that phone?
I received that phone on May 26, 2019.
Where were you?
I was in my workstation at the Fairfield Police Department.
What type of phone was it?
That was an iPhone XS.
Was it powered on?
It was powered on. It was locked. It had a lock screen, an active lock screen, and it was in airplane mode.
Did you get a password?
I did.
And were you able to open it?
Yes, I was able to open it.
What acts, if any, did you take on the phone?
Aside from unlocking it, the next thing I did was paired it with Gray Key in order to conduct the extraction of the device.
By the way, did you have authority to conduct the search?
Yes, Detective Patton provided me with a signed search warrant, which I did see.
So you utilized Gray Key. Did you also then analyze it with Cellbrite?
Yes, after the extraction was conducted, it was downloaded and then it was parsed or opened with Cellbrite.
Did you utilize that hash value process to ensure that the data was the same?
Yes.
And is that something that you normally do as a digital forensic examiner when you process a phone?
Yes,
Did you create a UFED reader?
I did.
Now, did you also utilize Gray Key and Cellbrite and extract the data, creating a UFED reader on a second phone that was seized from Photos Doulos in 2019?
Yes.
And did you also create and I could be saying this wrong, so please correct me if I do. Did you apply Cellbrite or a newer version of technology in 2023 on both the first phone as well as the second phone?
Yes, I took the most updated version at that time of Cellbrite and reparsed the original extraction on those dates.
Okay, you reparsed the original extraction. What was the purpose of doing that?
To attempt to view the original data set with newer technology, again, to be able to see if we were able to view anything newer that wasn't available back then.
Now, I want to ask you a couple questions with respect to the first phone that was seized on May 26th and is it reparsed or reanalyzed in 2023?
Both work, yeah.
Both would work. Okay. Did that 2023 report contain anything that was not, actually withdraw that, that's an awful question. In 2019 report, everything that was included in the 2019 report, did that appear in the 2023 report?
Yes, it appeared.
Okay. And specifically with respect to location data, I'm going to ask you a couple questions. You talked a little bit about some of the location data points you can get from a phone. Were you able to determine any location data points for the phone of Photos Doulos on May 24th, 2019?
Yes, I was.
Now, I'm going to ask you specifically about the time period between 5:35 in the morning and 12:22 in the afternoon. Did you review the Cellbrite UFED report for location data for that time period?
Yes, I did.
Now, what does that look like when you look at it on a map? Or I'm sorry, not on a map, on the UFED reader.
So it would appear on a map on the UFED reader. As I explained, there would be a table below a map. The table would have all of your information as far as the date, time, location data, longitude, latitude type of thing. And then there would be a map above it where you could then click on a data set and it would put a pin on that map and show you where the GPS fix for that device was.
On May 24th, 2019, between the time period of 5:35 and 12:22 that morning, what was the first time that phone indicated a location time point?
I don't recall that off the top of my head.
If I may have a moment with counsel. Your Honor, state's offer is 131. I believe if I can move it all, except there are 18 files contained within it, all except file 18, which when we get to that, I will make an offer at that time.
Is there an objection?
One moment, Mr. Chairman. I'm sorry, may I have a moment?
Yeah.
there's no objection to the other ones, Your Honor.
Thank you. States 131, except for file 18, admitted as full.
Thank you, Your Honor. Now, sir, I'm going to draw your attention to the screen behind you. I'm opening file 1 titled Redacted Device Locations. If you can, sir, if you wouldn't mind getting up and going to the screen for a minute. What's being displayed on the screen, sir?
So this is a PDF version of an extraction report for location.
Okay, I'm going to scroll up on the top. It says Cellbrite with extraction report. Did you create this?
Yes, I did.
Okay. 13. What is the time that it began? So is the time backwards?
Yes, it looks like the earliest timestamp is at the bottom and the latest timestamp.
Now, between 5:35 a.m. and 12:22 a.m., what was...
At first, after her grand jury testimony was over, but Kayla knew it was coming. And roughly 2 weeks later, on June 3rd, when Kayla checked in as part of her bail conditions, it did. It came. She was arrested for lying before the grand jury. Kayla had a new story prepared, but with the new charges, the state had the upper hand. She was allowed to give her new story with the agreement that her statements could not later be used against her. But there was no guarantee of a deal, and instead, Kayla would only get that deal that she wanted if her statements helped the police figure out what happened to Harmony. And if the state decided that Kayla's statements were not helpful, she would be facing not only the charges she was already facing, but now 2 more felony charges, this time for perjury, perjuring herself before the grand jury, plus any charges that could come about if the police were able to figure out what happened to Harmony without her statements. And Kayla knew that the police were going to follow up on what she now said. And without something to corroborate this new story she was going to give, there wouldn't be any reason for the police to accept it. After all, she had already lied to the grand jury to point the finger at Adam. So instead of the truth, she told a lie of a brutal killing where she was also a victim. But because there cannot be any corroboration for the lie itself, Kayla intermingled some of the truth of how she and Adam covered up Harmony's death. The lie itself cannot be corroborated, but there would be corroboration in the truth of the cover-up. Because Kayla's new story was not true of how Harmony died, she lacked real memories to draw from, and the details did not fit. Both the details she provided and the ones she did not provide. And it is in those details, details based on a lie, that begin to reveal the lie still being told by Kayla. At first, Kayla's new story for the police, when she gave a proffer on June 3rd of 2022, her new story was that it was the middle of the night, 2 or 3 a.m. Harmony had been having trouble controlling her bodily functions while the family had been living out of the car, and Harmony went to the bathroom again. Adam responded by repeatedly punching Harmony, probably like 10 to 15 times. That story changed to Adam assaulting Harmony in the morning before they went to the clinic for their methadone. The story then continued by saying that Adam struck Harmony again after getting back in the car from the clinic. Then, as they drove to Burger King because Kayla wanted to get something to eat for her and the kids, the story expanded to Adam punching Harmony as he was driving into the Burger King parking lot. Kayla claimed to recall Adam commenting that the last strike was different. He thought he hurt Harmony. Kayla did tell the police that she put an arm up briefly to try and stop Adam, but to no avail. Adam drove up to the Burger King drive-thru. They ordered their food. Adam paid cash. The family got their food and drove back to the Colonial Village apartments with Harmony moaning in the back. That's her story. And when asked, Kayla claimed that she fed the kids. She told the police that she went up to her friend Anthony Bodero's residence to get some drugs for she and Adam to use, leaving Adam alone in the car with Declan, Seamus, and Harmony. This whole entire story was not true. Excuse me. One of the things that you'll see that reveals her story about punching to be a lie is that she is unable to describe a true scene. She does not describe 2-year-old Seamus crying as his sister beside him is being struck. She does not describe the baby screaming as violence and chaos break out around him. She does not describe trying to soothe or quiet the children. Nor does she describe Adam reacting at all to what would have been a cacophony of screaming and crying had all that punching been true. She does not describe trying to hide a broken child from the Burger King cashier or any concern on Adam's part that Harmony might be seen by the cashier or the camera. She does not describe Harmony as she feeds, piece by piece, food to Seamus, who is next to her in the back seat of the car. She does not describe seeking help from her friend she got drugs from. She doesn't describe any concern by her friend, Anthony Bordero, that she seems upset. And please keep close attention to Kayla's various descriptions of the car breaking down, where she claims that she and Adam first discovered that Harmony is dead. Kayla told the police that with Harmony in what would have been a critical, perhaps fatal condition in the back seat, the family decided to drive away from their corner in the back of the Colonial Village apartments. Yet, Kayla did not remember where they were going. Then the car broke down at the intersection of Webster and Elm, and they discover Harmony's dead body in the back seat. Kayla talked about waving, honking, agitated drivers behind them around the car as Adam manhandles a dead child in the back seat into a duffel bag. And no one notices. Their car did break down on December 7th at the intersection of Webster and Elm. That is not in question here. And the family did walk back to Bodero's. But Harmony's body was already in the duffel bag, in the trunk, from when they discovered her death in the early hours of the night before. Yesterday, before we broke, the court gave you a partial set of instructions on how you are to go about deciding this case. Among them was an instruction on assessing the credibility of witnesses. It is up to you to determine the credibility of witnesses. But the judge did suggest an illustrative list of factors to consider in making that determination. One factor is whether what the witness said appeared reasonable. In discerning this, details matter. The details that are given and the details that are not. Is the witness pulling from a well of true memory or just making it up? Another factor the court has offered for your consideration is whether what the witness said is consistent with other evidence in the case. And that leads me to some of the science that was used in this case. Kayla also described Adam cleaning up blood spilled by Harmony with a kerchief. That lie was exposed by a special test that can reveal blood traces, even blood that was supposedly cleaned up. Luckily for the police, they were able to locate the broken down Sebring 2 years later. They're able to bring it to their lot at the police station, and they were able to search and test it with a special test that could detect invisible blood, blood that cannot be seen with the naked eye. No traces of blood, including on the back passenger seat where Kayla said Harmony bled and Adam cleaned it up. In offering guidance in assessing witness credibility, another common sense factor offered by the court is whether the witness had a bias or motive to lie. There will be time during Kayla's testimony, during direct and cross, to explore the changes, the inconsistencies, and details within her story, both those that are there and those that are not. And you just heard about the science to also assist you in evaluating Kayla's claims. But here, what follows is an example of Kayla's motive to lie at play, of Kayla taking something true and twisting it to point the finger at Adam, yet hide her own involvement. In telling the police how Harmony's body was finally removed from their lives, Kayla described an incredibly disturbing treatment of Harmony's body, her remains in the refrigerator before being placed in the shower, under hot water, washing away the fluids. Kayla at first said it was all Adam, and he wouldn't even let her in the bathroom. But she slipped up, and fortunately the interviewers caught it. They caught the slip and they probed. Kayla had to admit that she was part of it too. She cut off Harmony's hoodie in the shower, and she and Adam bagged up Harmony's clothes. And when that was done, Kayla and Adam put her remains in another bag, with Kayla helping Adam to zip that bag up. You will hear that after Adam and Kayla permanently hid Harmony's remains, that their relationship became more frayed. Adam struggled with the loss of Harmony and his mental health suffering. Adam and Kayla separated briefly. That was in the spring of 2020 before reconciling. But Adam continued to spiral, and a year later was arrested after another episode. He went to rehab, then stayed at a sober house before going to Maine with Kelsey Small, which was where he was in December of 2021 when Kayla told him to return to New Hampshire and help her deal with the police. Joined with the murder and related charges is a second-degree assault charge. That allegation is that Adam knowingly caused bodily injury to Harmony in July of 2019 by striking her in the face with a fist. Harmony did get a black eye during the summer of 2019, and no question about it, Adam did react when he saw Harmony trying to smother her brother, jerking her away to stop her, but that is not what caused the black eye. On July 22nd of 2019, Kevin Montgomery, Adam's uncle, came up from Florida to the house. He saw Harmony's black eye, prompting a conversation about her. During this conversation, Adam told Kevin about a time when he walked in to find Harmony smothering then 5-month-old Declan. Harmony had her hand wrapped around his mouth, causing him to turn blue. Adam pushed Harmony away while checking on Declan. Then, a week later, upon returning to Florida, I believe it was July 29th, Kevin made a report to New Hampshire DCYF, and he told DCYF that Adam gave Harmony a black eye, conflating what Adam had said. A veteran caseworker, Demetrios Saros, responded that very same day, the 29th, to investigate. Though the encounter was brief, he did see Adam and Harmony outside the house getting into a car, and when he saw Harmony, he observed no concerns. He also followed up, paying another visit on August 7th. This time he did see a small red mark in Harmony's right eye and faded bruising under the eyelid. He spoke to Harmony alone, asked probing questions to find out what may or may not have happened, and then, after doing his job, left the visit satisfied that there was no substantiated evidence of abuse. I am getting ready to step down, but before I do, there is just one more instruction I need to discuss. The court has instructed you that you are to decide this case not on sympathy, but on the evidence and the evidence alone. This case involves the tragic and senseless death of Harmony, an innocent 5-year-old, and it triggers perfectly understandable, innate human emotions, and it would be inhuman not to feel them. But as was discussed during the jury selection process, and as you've been instructed by the court, you all have a difficult yet necessary task: deciding this case not on emotion, not on sympathy, but on the evidence. And after you have heard all the evidence, after you've heard all the evidence in this case and apply the facts to the law, you will know that Adam did not murder his daughter or engage in witness tampering with Kayla. Kayla was an equal participant in the cover-up. She alone knows how Harmony died, and she won't tell. At this trial's conclusion, we will ask you to follow the evidence you have heard and find Adam not guilty of murdering his daughter, witness tampering with Kayla, and second-degree assault.
All right, ladies and gentlemen, you've now heard opening statements. As I told you when I gave you my preliminary instructions, we would generally be taking a mid-morning and mid-afternoon break, and I do look for natural breaking points in a trial to do that. I think this is one of them. So what we're going to do is we're going to take a 15-minute break now, so use the restroom, have a drink of water, and we'll come back in 15 minutes and begin the evidence. All right, all rise for the jurors, please. Maybe seated, counsel, approach for just a minute. the new exhibit.
Yes, ma'am.
You can sort of do it simultaneously. If you have a witness advocate, they can bring them in. I'm going to bring the jurors in now. Okay. All rise for the jury, please.
All rise for the jury.
Please be seated. When the state is ready, you may call your first witness.
Your Honor, the state calls Michelle Raftery. And Ms. Raftery, if you just remain standing and raise your right hand. Do you swear that the testimony that you will provide will be the truth and nothing but the truth under the pains and penalties of perjury? Yes. You can make yourself comfortable, Ms. Raftery. There's a microphone in front of you. But I'm just going to ask that you speak into that so that everyone can hear what you're saying. Can you begin by stating and spelling your last name for the record?
Yep. Michelle Raftery, Raftery.
And what's your date of birth, Ms. Raftery?
9/11/70,
Where do you currently live?
Haverhill, Massachusetts.
And how long have you lived there?
In Haverhill, about 25 years.
Who do you live there with?
My husband and 3 of my children.
And what's your husband's name?
Timothy.
And your children? What
The
are
ones
their
that are home?
ages?
Oh, their ages?
Yes.
Ben's 25, Jaden is 14, and Claire is 13.
And do you have children that live with you?
Those are the ones that live with me. Yeah.
What do you do for a living?
I'm a behavioral health partner
And how long have you done that?
for a year.
Prior to that, what did you do for a living?
I was a FRL, a family resource liaison.
And can you explain what that is to the jurors?
Yes, I work with foster parents and I help support them and run support groups and trainings for them.
Do you have any experience as a foster parent yourself?
Yes, I do. Over 13 years.
And can you tell the jury about that experience?
Yes, we had the privilege of being Harmony's foster parents.
And you mentioned a name, Harmony, just now.
Yep.
Who is she to you?
She was our foster daughter.
What did she call you?
Mama.
Your husband, Tim, what did she call him?
She called him Dada and Papa.
You said that you'd been a foster parent for 13 years?
Yep.
What point in that timeline, those 13 years, did you take Harmony in?
Like probably halfway through. Probably halfway through the years. Yep. So she came to us at 2014.
And tell us about that.
Yep. So you always start off, you get a phone call from DCF, and they tell you a little bit about the child. And Harmony was 2 months old at the time, and she had a pretty intimidating diagnosis at first. So, I did a lot of Google research, but I still knew that we wanted to say yes, and Harmony came and lived with us when she was 2 months old.
Pretty intimidating. What were you told about Harmony before
So
you took her?
we were told that she has hydroprocephaly, which is like a disorder with her brainstem. And we were told that she was legally blind in both eyes, and that she probably wasn't going to live 7 months.
I'm sorry, can you say that last thing?
Yeah, that she probably wasn't going to live past 7 months old. Hydroprocephaly was the original first diagnosis.
You mentioned this blindness.
Mm-hmm.
What can you tell us about that?
So at that time, she had a whole team of doctors, and she was considered legally blind in both eyes. However, I started to notice when I would feed Harmony that she would track me with one of her eyes, at least one of her eyes. And, then we went on to get different diagnoses for her.
You mentioned having Harmony since she was 2 months old.
Yes.
What was Harmony's date of birth?
6/7/14.
June 7th, 2014.
That's correct.
What kind of child was Harmony Montgomery?
She was a loving child. She was very sweet, very happy. She was super social. She loved to be with people. We used to joke around with her to leave a sparkle wherever she went, because wherever she went, she left people happy, and you knew that you met her.
How long was Harmony in your care for?
So, which time? We took care of Harmony 3 times. She came back into care 3 times. So for the first time, she was with us for about 2 months. Then she returned to her mother, and then she returned to us. And then she stayed with us for about a little over 2.5 years, and then she went back with her mother, and then came back 10 months later.
You mentioned these disabilities.
Yes.
Was Harmony developmentally delayed?
She was not. It definitely could have been a possibility. She started off with that original diagnosis, and through going through testing, she had a neurologist, endocrinologist, ophthalmologist, and we had a whole team of specialists that worked with her, and they changed the diagnosis to septo-optic dysplasia.
And were you taking any steps when she was in your care to treat her needs?
Yeah, absolutely. Harmony had, like I said, a team of doctors, but she also had early intervention workers. So she had 2. She had a nurse that came weekly, and she had a vision specialist that came weekly, and we did all the treatments and the programs that she needed with that.
Was she meeting benchmarks at that time?
She was meeting every benchmark. She was succeeding, yeah. Yep.
Ms. Rafferty, when was the last time you saw Harmony Montgomery?
The last time I saw Harmony was December of 2018.
Your Honor, may I approach the witness?
Yes.
So, Your Honor, I'm showing the witness what's been marked for identification as State's Exhibit 97. Ms. Rafferty, do you recognize this?
I do.
I'm going to get close to a microphone so I'm picked up. What is this?
That's the day that they were doing school pictures, and she wanted to have a sparkly blue dress.
And do you recognize the person that's depicted in this picture?
Yes.
Who is it?
It's Harmony Montgomery.
Is this a fair and accurate representation of Harmony as you remember her?
Yes.
Your Honor, at this point I move to admit as State's Exhibit 97.
No objection. All right, the ID is stricken. It's entered as a full exhibit.
And I move to publish at this
You
point.
may
Your Honor.
publish it.
Mrs. Rafferty, do you know someone named Adam Montgomery?
I do. Yes.
How do you know him?
He was Harmony's biological father.
Would you recognize the defendant if you saw him again?
Absolutely.
Your Honor, may I approach you?
Yes, you may.
Showing the defense what's been marked for identification as State's Exhibit 101. May I approach the witness?
Yes, you may.
Ms. Rafferty,
Yes.
do you recognize this item?
Yes.
Can you tell me what it is?
It's Adam Montgomery.
And Your Honor, at this point, is this
It's
a fair
a picture, yes.
Is this a fair and accurate representation of Adam Montgomery as you remember him?
Yes.
I move to Marcus Full, Your Honor, to strike the ID on Marcus Full, State's Exhibit 101.
Any objection?
No objection, and we agree that that is a photo of the defense.
Okay, thank you. The ID is stricken. It's entered as a full exhibit.
And I move to publish it at this
You
point.
may publish it.
Ms. Rafferty, was
I'm sorry, Attorney Knowles, would you return the exhibits back to the table when you're done with them, just so that everything remains there, unless you're going to use it shortly
Absolutely.
again? Thank you.
Ms. Rafferty, was Harmony potty trained when she was in your care?
Yes, she was. She started at our house, and then she finished when she moved back with her mother.
And how old would she have been at that point in her life?
So at 2.5, going on 3, she was potty trained.
What steps did you take to, you said she started at your house. What
Yeah.
steps did you take to potty train her?
Harmony was very easy to potty train. She didn't like to have, soiled clothes on, and she wanted to be like the bigger kids that were in our house. So she would tell us it was pretty much Harmony potty trained herself.
You mentioned her mother. Do you know
Yes.
her name?
Yes.
Can you tell the jurors?
Yes, it's Crystal Sorey.
And you said that Crystal Sorey finished her potty training?
Yes.
Did Harmony return to your care after that?
She did, yes.
And after Harmony returned to your care, did she have any bathroom accidents?
Absolutely not.
If I could have just a moment, Your Honor. Ms. Rafferty, I don't have any additional questions for you. The defense attorney may.
Okay.
Thank you.
Thank you.
Thank you, Your Honor. Good morning.
Good morning.
And I know this is difficult, and I won't be long, okay?
I'm sorry, we need to get you a microphone, and we'll figure out the other podium if you want to do that, but we might as well set it up.
I'll just take it over for now. I only have a few.
Yeah, that's fine, if you want to start there.
I've been pronouncing your name all this time wrong. Rafferty?
It's Rafferty, yes.
And quite a birthday that you have, too.
That's right.
Yeah. So you said that you had Harmony placed with you 3 times.
Yes.
In between, she was with her mother.
Yes.
And then she would be returned to you.
Yes.
And how long was the most recent time how long was she with you the last time she was placed with you?
About 10 months.
Okay. And from being placed with you for about 10 months, she went to another foster care?
Yes.
And you felt like she had more needs than you could deliver, so she went to a therapeutic foster care?
No.
Miss Kumba? That's not?
I don't know that other foster parent.
Ah, okay. So she didn't go to therapeutic foster care?
She went to another foster home.
Okay. Not a therapeutic one?
Not that I know of.
Okay. Had you asked that she be placed in a therapeutic foster home?
No.
Okay. She left your home for another foster home for what reason?
It's a long story. Co-parenting a child that has trauma, first of all, is very difficult. Co-parenting a trauma with DCF involvement and co-parenting with them is extremely difficult.
Okay. So Harmony was placed with you 3 times, and that last time she was then placed to a therapeutic foster home.
She was placed in another foster home, yes.
Okay. I'm sorry. I
Yep.
did misspeak. Speak. She went to another foster home.
Yes.
Okay. Thank you.
Your Honor, no further questions for this witness. I'd ask that she be excused.
Any objection? All right. You may step down and
Thank
you are
you.
excused. State may call its next witness.
Exactly, Your Honor. The state would like to call Ms. Crystal Sorry to the stand. Sorry, when you get here, if you could just remain standing for a brief moment.
Sure.
If you would please go ahead and raise your right hand. Do you solemnly swear to this jury that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Ms. Sawyer. Please feel free to have a seat. Ms. Sawyer, since we're being recorded here today, and there's a microphone right in front of you, so I will ask you to please keep your voice up to make sure that the recording picks you up. Would you please state your full name and spell both your first and your last name?
My name is Crystal Renee Sorey, Crystalsorey.
And Ms. Sorey, what town do you live in?
I live in Fitchburg, Massachusetts.
How long have you lived there?
A year and 5 months.
And how far did you go in school?
I didn't graduate high school.
I'd like to ask you about a specific day, June 7th, 2014. What significance, if any, does that day have for you?
It was the day my daughter Harmony was born.
And Harmony was a girl, correct?
Yes.
Have you had any other daughters besides Harmony?
No.
And what was her full name?
Harmony Renee Montgomery.
Same middle name as you?
Yes.
What was her medical condition when she was born?
She was blind in her right eye. She was misdiagnosed twice before that. Yeah, just blind in her right eye.
And after about 3 months after she was born, who did she go to live with?
Michelle Rafferty.
And do you know Michelle?
Very well.
Why did she go to live with Michelle?
I am a recovering drug addict. I was struggling at the time, handling her diagnosis. I was struggling.
Is it fair to say that who you are now in 2024 is different than who you were in 2014?
Very.
In March of 2016, were you able to obtain custody of Harmony again?
Yes.
Okay. Where did the two of you live?
First, when she reunified, I was at Casa Esperanza in Roxbury. It was a reunification program, but you could only progress so much there. So then we moved to Ruth Kelly Umi's house on the other side of Roxbury, Dorchester.
Okay. When the two of you were living together, how was Harmony?
Amazing, rambunctious, very smart. By the time she was 2, she could tell you her whole life story.
She was talkative?
Yes. People didn't believe she was 2.
When you got custody and were reunified with Harmony in those two places, did you work and finish potty training with Harmony?
Yes,
Okay.
I did.
And how did she take to that?
She did very well, honestly. I was kind of surprised. She was just really excited to be a big sister. Her brother had diapers, and I told her, babies wear diapers, and you're not a baby anymore. You're a big sissy. So she was right on it, and she did so well.
In September and then October, I know you were reunified in March of 2016. In September and October of 2018, did she go to live again with Michelle Rafter?
Yes.
And when she left then, that would be the fall of 2018, how old was she?
2018. 3. I believe 3, almost 4.
Yeah, basis?
It's leading and with, I think the dates are wrong.
Your Honor, I believe the question was how old was she in the fall of 2018?
Objections overruled.
Thank you. So she was born in 2014, is that correct?
She was 4, yes.
Okay, so she was 4 in 18.
Yes.
And was she fully potty trained when she left you?
Yes.
I'm going to ask you, who was Harmony's birth father?
Adam Montgomery.
And how did you meet him?
Through a mutual friend.
Was he living with you when Harmony was born?
No.
Were the two of you living together when Harmony went to live with the Rafteries?
Never.
Did you ever have any other children with Adam Montgomery?
No.
At some point in 2019, who got custody of Harmony?
Adam.
Where was Adam living at the time?
Manchester, New Hampshire.
Do you remember what street he was living on?
Guilford Street.
And is that where Harmony was as well?
Yes.
What, if any, visits did you have with Harmony after she went to live with Adam Montgomery?
I had 2 physical visits with her. And then I had 2 FaceTime calls, both very brief.
The physical visits, where did you visit her?
Excuse me. Guilford Street.
Did you visit with her outside the home or inside the home?
Inside the home.
Inside the home. Did you see where her room was?
No.
Okay.
He never showed me.
When you say he, who is he?
Adam never showed me. I was only allowed in the living room or the bathroom.
How did you communicate with Adam at that time?
Facebook.
Facebook?
Yeah, he wouldn't give me his number.
When did you last see Harmony?
April.
April
2019.
April of 2019?
Yeah, right before Easter.
How did you see her?
Oh, I was doing a Facebook video call. That was how I had job training, so I couldn't do a physical visit that week because I didn't know my schedule.
You said that was before Easter, is that correct?
Yes.
Did you see her on Easter?
Yes.
Were you able to see her after that?
No.
What did you try to do to be able to see her or talk to her after that?
I just kept reaching out to Adam and Kayla and, asking, begging them to let me see her, and I was sorry for whatever I did. I wasn't even sure what I did, but I was just trying to reach out to really anybody at that point, his family, his grandmother, his uncle, his dad, anybody.
Okay. Let me ask, did you try to reach out through the months of May and June?
Yes.
What about in July?
I believe so.
Okay. Did you receive any phone call from Kevin Montgomery, Adam's uncle, in July?
Yes.
I'm not going to go into the detail of what was said, but after that call, did you continue these efforts you talked about before, trying to get in touch with Adam?
Yes.
And what about September of 2019? Were you trying to get in touch with Adam then?
Yes.
What about October and November of 2019? Were you trying to get in touch with Adam then?
Yes.
Christmas of 2019?
Yes.
In touch with him then?
Yes.
Were any of those successful?
No.
Did you see or hear from Harmony at all during that time period?
No.
What about in the year 2020? Did you continue to try to find and get in touch with Harmony or Adam?
I'm sorry, can you repeat that?
No problem. What about the following year, in the year 2020? Did you try to get a hold of Adam and Harmony?
Yes, I had made a new Facebook hoping, because he had blocked me and so did Kayla, I was hoping to get through to him that way.
Did you try also through 2021?
Yes.
By December of 2021, what else were you doing to try to find Harmony
I was
to respond?
Calling DCF. I was, telling my therapist, talking to anybody that I knew was either a mandated reporter or had some type of leverage because I wasn't getting anywhere. I had wrote also to the mayor.
And in December of 2021, did you have any meetings with the Manchester Police Department?
I'm sorry.
Yep. In December of 2021, did you meet with the Manchester Police Department about trying to find Harmony?
Yes.
And with regards to that, did you provide them with any permissions to try to get more information to help find Harmony?
I signed whatever they needed me to sign.
Did any of that include medical authorizations for medical records?
Yes.
Did you provide a DNA swab for them?
Twice.
Did you provide permission for them to look at your Facebook account?
Yes.
Did you provide permission for them to find out where you had been living and contact those places to confirm your dates there?
Yes.
Sorry, I'm going to show you. It's been marked State's Exhibit 101.
For identification?
Your Honor, I believe we made this a full
I'm sorry, that's full exhibit, thank you.
Do you recognize this person?
Yes. Adam Montgomery.
This is the person that you were trying to get a hold of?
Yes.
Show now State's Exhibit 97. What's this?
That's my girl. That's Harmony.
In the fall of 2018, when she went back to Rockets, do you know that if she was going to school?
When she was with Michelle, she was, but not after.
Not after.
No.
Could you explain what you mean by that? Not after?
When she went with Adam, she never went to school.
I'm sorry, Your Honor, if we could approach. Ms. Sori, I just have one last question for you. With regards to all of those communications that you talked about through 2019, 2020, 2021, trying to get a hold of Adam Montgomery or Harmony, for any of those, were you ever able to speak with Harmony?
No.
If I can have just a moment, please. And just to clarify, Ms. Sori, the last time that you saw her, I believe your testimony before was April of 2019?
Yes.
So it was not around Thanksgiving time of 2019?
No.
Thank you. I have no further questions for you, Ms. Sori. I believe defense counsel will have a few.
I'll pull it out after this. I'll pull it out after this, because I only have a couple of questions. And it sounds like Harmony was a lovely child and a joy, is that right?
Yes.
And you described on direct her getting potty trained and you comparing her to her brother?
Yeah.
Your son?
Yes.
And I think she loved being a big sister to her brother, your son.
Yes.
Right? And you described how old Harmony was in September of 2018, I think. Harmony was not living with you at that time, is that right?
That's right.
Okay. Thank you.
Nothing further, Your Honor.
All right. You may sit down. Just be very careful of the wires. Okay. The state is ready. You may call your next witness. So, you know, just keep it to the side a little so that when the witnesses are coming through, that's fine. Just the podium up. No, good. I got that. Will you handle this? Thank you so much.
Your Honor, the state's next witness is Dee Travers. I believe the defense counsel indicated yesterday outside of the courtroom that they wish to speak with you about State calls D.D. Travers to the stand. Good morning, Ms. Travers. Thank you so much. Please remain standing for a brief moment and raise your right hand. Do you solemnly swear that the testimony you give this jury will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please feel free to have a seat. Ms. Travers, let me just ask you, since we're being recorded here today, would you please state your full name and spell both your first name or the initials you go by and your last name for the record?
Sure. My first name is D.D., just spelled as D.D. Last name is Travers, T-R-A-V as in Victor, E-R-S.
And Ms. Travers, do you live in the state of New Hampshire?
Yes, I do.
How long have you lived here?
Approximately 20 years.
20 years. And currently, where do you work?
I work for a Catholic Medical Center in Manchester.
What do you do for them?
Currently, I work as a nurse practitioner.
And how long have you been working as a nurse practitioner for them?
I've been working about 5 years as a nurse practitioner.
And prior to that, were you also working for CMC in a different capacity?
Yes, I was working as a registered nurse.
Let me ask you, at any point were you assigned to work at the affiliate for Catholic Medical Center, the urgent care in Bedford?
Yes.
And I'd like to direct your attention specifically to June 2nd of 2019. Did you take vital signs from a child named Harmony Montgomery that day?
Yes.
And as part of those vital signs, did you measure and record her weight?
Yes.
How much did Harmony Montgomery, the patient that you saw that day, weigh when you saw her on June 2nd of 2019?
I don't recall the actual number.
Let me ask, with regards to those, when you measured her weight, did you record that information somewhere?
I would record it in the electronic health records.
Okay. And with regards to the electronic health records, when do you record that? So,
Generally, it's done in the room with the patient.
so right then and there, while you're with the patient, you're recording that?
Yeah.
Okay. And if you had a chance to look at those records, do you think that looking at those records might help refresh your recollection as to what the weight was that you took on that day?
If I could look again, I could remember the number. Yeah, that'd be great.
Do you want to approach page 4822? Do you recognize that to include the medical records that you entered that day?
Yep, it has my name right there.
Okay. And I'm about to say, I'm going to have you go ahead and take a look at it for a moment, and when you're ready, just look back at me. I'm going to ask you what her weight was.
Okay.
And does that, looking at that, does that help refresh your recollection of the weight?
Yes.
Okay. And how much did Harmony Montgomery weigh in June of 2019 when you measured her?
35.20.
35.20. And are those grams, those pounds? The
I'm sorry, I didn't look at that. I apologize.
That's all right. I'm sorry. The 35.20, is that pounds? 35 pounds? Or 35.20 pounds, I should say?
I didn't actually see that it said pounds on there, but
Okay. Let me ask, do you typically, when you do your measurements, are they in pounds or are they in kilograms?
They're usually in kilograms.
Usually in kilograms?
Mm-hmm.
Okay. Well, I want to make sure that your memory is fresh. So with regards to the record, do you recall off the top of your head whether it was 35.2 kilograms or 35.2 pounds?
I don't recall.
Okay. And having a chance to look at the vital signs again, do you think that might refresh your recollection?
Sure.
Same page? Let's say, does that help? I see you nodding your head up and down. Does that help refresh?
Yes, yes.
Okay, so that 35.2, are those pounds or kilograms?
Pounds.
35.2 pounds. All right, thank you very much, Nurse Travers. I greatly appreciate it. I don't have any further questions for you. I believe defense counsel may have a few.
think Harmony's weight was appropriate for her size and age?
Foundation.
Just a couple of more questions. Did you stay in the room until the doctor came in to look at Harmony?
No.
Okay. So you just pretty much take that information and give it to the doctor for the doctor to do the examination?
That's correct.
Okay. And you don't know the results of the examination, is that right?
No.
Okay. Thank you.
Any further?
No further, we ask the witness to be excused, please.
All right, any objection to her being excused?
May I ask one more question, Your Honor?
Okay, go ahead.
Okay, I'm sorry. But one of the observations that you did make was the sores around her mouth?
That's what I wrote in the report, yes.
Okay. And that was a rash or sores around her mouth that she was present for, right?
Yeah, that's what I wrote in the report, yeah.
Thank you.
Any objection to her being, do you have any follow-up questions from that?
We can just have a brief.
Yes.
No questions, and we would ask the witness to be excused, please.
Any objection to her being? No objection. All right, you may step down and you are excused.
Thank you.
call its next witness.
Your Honor, at this time, the state calls Mr. Kevin Montgomery to the stand. Watch your step, there's a couple of cords there.
Remain standing for just a moment.
Thank you. Mr. Montgomery, if you would please go ahead and raise your right hand. You solemnly swear that the testimony that you will give this jury will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you, sir. Please feel free to have a seat. Mr. Montgomery, as we are being recorded here for the record, could you please go ahead, and I'm going to ask you to please go ahead and state your name, both your first and your last name.
Hang on one second. Could you carefully open that? Otherwise, it sort of the top can open. Thank you.
Thank you, sir. If you would please go ahead and state your full name and spell out both your first and your last name for the record.
Kevin Lester Montgomery, Kevin Montgomery.
And Mr. Montgomery, what town are you living in now?
Malden, Mass.
Okay. How long have you lived down there?
I've been back in the area since June.
June of this year?
Last year.
June of last year.
23.
Of course. Sorry. And are you currently working?
I am.
What do you do for work?
I am a plumber.
And how far did you go in school?
10th grade.
How long have you been a plumber?
Roughly 3.5 years-ish.
What are some of the other kind of jobs that you had before being a plumber?
Landscaping. I was in the drywall, union, roofing,
Okay.
stuff like that.
I'd like to ask, in 2019, where were you living at the first part of 2019?
2019, first part of 2019, I was living in Manchester,
And what was the street address that you were living at?
77 Guilford Street.
Who owned that home?
Excuse me?
Who owned that home? Sorry.
My mom and my ex.
And who else lived there? Let me ask, let's say in February or March of 2019, who else lived there?
So it was me, my nephew, his wife, and their kids.
And who's your nephew, sir?
Adam Montgomery.
And who was his wife at the time?
Kayla Montgomery.
I'm going to go ahead and show you State's Exhibits 1 and 2. And just see if, let's just talk about State's Exhibit 1 for a moment. Do you recognize State's Exhibit 1?
I do.
Okay. And what is that a photograph of?
The front of the house.
Which house?
77 Guilford Street.
Okay. And what about, and with regards to that photo, did the house look that way when you were living there in 2019? And by that, I just mean where the windows are, the door is, the color.
Yes.
And now I'd like to show you State's Exhibit 2 for identification purposes only. Do you recognize what that is a photo of?
I do.
What's that a photo of?
That was Harmony's room.
Where was her room, inside this house or somewhere else? Did she live with you?
Yeah, her room was across from my room inside that house.
Other than the stickers that are at the bottom here, and the photograph itself of the room and the home, are these accurate to your memory of what that room used to look like and what this home used to look like generally when you were there?
Yes.
At this point, Your Honor, I'd ask for the identifications to be stricken from State's Exhibit 1 and 2, please.
Without objection. I'm sorry. No, without objection. Okay, the ID is stricken. They're entered as full exhibits.
So, Mr. Montgomery, I'll go ahead. Permission to publish it.
Yes, you may.
Thank you. With regards to State's Exhibit 1, this is 77 Guilford Street? Is that correct?
Yes.
And let me ask you, how many bedrooms were in the home? How big a house are we talking about?
Living room on the first floor, 2 bedrooms in the back, and then like an attic that was like made over upstairs.
When you say made over upstairs, was that also used as a bedroom?
Correct.
And now showing State's Exhibit 2, I believe you said before, I want to make sure I got your testimony right, that this was Harmony's room. Is that right?
Yes.
The stickers on the wall, do you know what that's a sticker of?
Yes, that was a Minnie Mouse.
Mr. Montgomery, excuse me. In 2019, you said, I believe before, that you said that your nephew, Adam Montgomery, was living with you. Is that correct?
Can you speak up, please?
Yes, certainly. And let me move closer to the microphone. In 2019, I believe you testified a moment ago that you said Adam Montgomery was living with you, and he's your nephew. Is that right?
Yeah. Okay. Yes.
Okay. And so, nephew, in terms of, so who's his father? And I would assume his father or mother is a brother or sister to you.
So his dad's my older brother, Michael.
And with regards to Adam, how long have you known Adam?
His whole life.
Were you subpoenaed to be here today to testify?
I was.
Okay. And let me ask you, do you want to be here today testifying about your nephew?
No.
When Adam came to live with you at Guilford Street, I believe you said before that he had kids with him and that he had his wife. Could you tell us what her name is?
Adam's wife?
Yes.
Kayla Montgomery.
And the kids that moved in with him there in 2019, who were they?
Um,
Do you remember their names, I should say?
I do. Could you say that question again, please?
Certainly. So when Adam and Kayla came to live with you, you said that there were kids in the home before. What were their names?
So when Adam and Kayla came in, who came with them?
Yes, exactly.
At first it was just Seamus.
Okay. And who is Seamus?
Seamus is their son.
Okay. Who came to live with you next after that? Which child came next?
I believe, 2019. So I believe a baby was born somewhere, and then Harmony.
And then Harmony. So Harmony was the last child to move in?
I believe so.
Okay. We looked at a picture of Harmony's room. Where was that room in the house? Was it upstairs? Was it downstairs?
So it was downstairs at the end of the hallway on the right,
Okay. And where was your room in the home?
right across the hall.
Where did you see Harmony spend most of her time when she was in the house?
Permission to approach, Judge.
So, Mr. Montgomery, let me just restate that question for you. So the question that I had for you is that when you saw Harmony, primarily what parts of the house did you see her in? Where did she spend most of her time that you saw?
Just everywhere.
Just everywhere?
Kitchen.
Okay.
Living room, just everywhere.
In July of 2019, did you stay in New Hampshire or did you go to any other state?
I lived in New Hampshire,
Mm-hmm.
and then I went for roughly 3 weeks to Florida.
Okay. And let me ask you about that trip to Florida. Did any other family members go with you on that trip?
My son.
Your son? Okay. And when you were in Florida, did you visit any family members?
I did, all my family.
Okay. Let me ask you, sir, when you were down in Florida visiting family, tell us some of the different family members that lived down there that you saw.
So, the trip was primarily to go see my mom, because my mom had some health issues. But I have several brothers, I saw them, nephews, sister, the whole family.
And I know testifying can be very difficult, so if you need a break or anything, you just let us know and let the court know, okay?
Okay.
All right. You said that you were seeing your mother and she had some health issues. What health issues did she have?
So I believe that April she had triple bypass heart surgery. Okay. And that's what the trip was based around, was going to see her.
And did you spend a lot of time with her during that July trip?
I did.
Okay. When you came back, do you remember what day you flew back into town?
Roughly the 22nd or the 23rd of July.
Okay. And I apologize, I made an assumption there, and I shouldn't do that. How did you come back to New Hampshire? Did you fly? Did you drive? Did you take a train?
We flew, James and myself.
And when you flew back, and who's James?
James is my son.
Okay. So when you flew back into town, did you fly into Manchester or into Boston or somewhere else?
Boston, Logan.
Okay. Did you come back to Manchester that same day after you got off the flight?
I did.
Okay. And did you go to visit 77 Guilford Street? Did you go home?
I did.
Let me ask you, when you got home, did you see Harmony there?
I did.
Where did you see her?
I see her standing in the kitchen.
And when you saw her in the kitchen, how did she look to you?
She had a black eye.
Can you describe it for us? How did the black eye look?
Full, like a raccoon's eye, black and blue.
Black and blue?
Yes.
And when you say full, what do you mean by full? Can you give us a good
All
example?
the way around.
All the way around. And I see just there you were pointing to your right eye. Did you see it on her right eye?
I honestly can't recall, but I think the left.
Okay, you think the left. Okay. I appreciate that for your honesty there. You said you saw her in the kitchen with this black eye?
Yes.
Okay. So when you saw her in the kitchen with this black eye, what, if anything, did you say? It's okay. Take your time.
Something along the words of, "Oh my fucking God, what did you do, Harmony?"
And who answered that question?
My nephew Adam,
Where was he?
standing right behind her.
And what did Adam say?
She didn't do anything. I bashed her around the fucking house.
Did Harmony ever say anything in response to the question, or just Adam saying, I bashed her around the fucking house?
I think just Adam.
How did Adam say this?
How did he say it?
Yes. Or let's put it this way. Can you say it the way that he said it so that we understand?
I'm not sure. If I had to describe it to the best of my ability, it would be like a cocky son of a bitch.
Did Adam tell you why he bashed her around the house and caused the black eye?
He did.
What did he say?
He said he was in the bathroom moving his bowels, and that he put Harmony in charge to watch Declan, and when he came out, Harmony had her hands over his mouth, and I guess his lips were supposed to be blue. That's what was explained.
That's what Adam explained to you?
Correct.
And after he explained that, how did he say he caused the black eye?
I bashed her around the fucking house.
Was there anybody else in the kitchen when Adam said this to you?
Just the three of us.
Just you, Adam, and Harmony?
Harmony.
Let me ask you, did you stay at your house that night?
I did.
What about the night after that?
I left the following morning.
Did you ever stay in the house after that? Overnight?
I did not.
When you heard this from Adam, who did you tell about what Adam told you and seeing the black eye? Who did you tell?
You want names?
Yes, please.
Told my mom. Told my son's mother, Christina. Told my sister, Erin. My brothers, Sean, Michael, and Richard. I told one of Adam's friends, Nick and Aaron. I told Harmony's mom, Crystal. I told Harmony's foster mom, Michelle. I think I told my sister Janine, my mother Helen. That's kind of what I remember. Could you just repeat the question again?
That's all right. I believe you answered the question.
Okay.
Let me ask, did you also make any calls to the what's called DCYF, or the Division of Children, Youth, and Families?
I did.
And the Nicholas and the Aaron that you referred to, is that Nicholas the same person as Nicholas Ahern?
Yes.
And is that Aaron the same person as Aaron Rue?
Yes.
Why did you tell all these people? Why did you call DCYF about this?
Say that again?
Yes. Why did you tell all of these people?
To get help.
Help for who?
For Harmony.
Did you ever see Harmony after that day?
I did.
When did you see her? And by when, I mean what time of year?
What time of year?
Yes. Mr. Montgomery, did you, and let me change my questions a little bit for a minute here. Did you see Harmony again in September of 2019?
I believe so.
And let me ask, on when you did see her, was it at 77 Guilford Street?
Yes.
And was that before Adam was evicted from the home?
Yes.
Did you see Harmony after they were evicted from the home?
No.
Mr. Montgomery, I'm going to go ahead and show you State's Exhibit 101. Do you recognize this person?
Yes.
Okay. And who is this?
That's my nephew, Adam Montgomery.
After Adam told you about causing Harmony's black eye, did you have any further conversations with him about that incident?
I did.
And what did he say to you in that later conversation about this black eye incident?
What did he say to me in the later conversation about the black eye?
Yes, sir.
I'm not sure what you exactly mean.
I'm about to say, let me back up and I'll clarify. Attorneys need to ask very clear questions. So you've described for this jury about seeing Harmony's black eye and Adam telling you that he bashed her all around the fucking house. Did you talk with Adam about that black eye at a different time, at a later time?
I did.
Okay. And at that later time, what did he say about having bashed Harmony around the house?
Can I explain?
So, if we could approach for a minute, Your Honor. Thank you, Mr. Montgomery. We just needed a minute to talk there. What I'd like to do is I'd like to ask I apologize. Let me ask a very clear question about this second conversation. When you were later speaking with Adam about this black eye incident, did he apologize to you for having hit Harmony?
Just yes or no, right?
With regards to the question, yes. Did he apologize to you? Did he say he was sorry for having hit Harmony?
Yes.
He did. Going into the fall of 2019, after the eviction, and then going into 2020, did you try to get in touch with Adam, with the defendant?
Give me the time frame again.
Yes. After the eviction, so in the fall of 2019, and going into the next January, February of 2020, and then going into the summer of 2020, did you try to get a hold of Adam?
I did.
Okay. And were you able to do so?
I got a hold of somebody on Facebook.
Okay. But what about Adam?
It's hard to remember.
If I can withdraw that question, Your Honor, I'll ask a different question. With regards to that, you said you got a hold of somebody on Facebook. Were you able to go into a conversation on Facebook, or were you ever blocked on Facebook?
Summer of 2020, correct?
Yep, fall of 2019 into the summer of 2020.
Right. The pandemic happened in 2020, right?
Yes, sir.
Like March, right? So that's like my first summer in Florida. Yes, I got. I believe I got in touch with someone on Kayla's account through Facebook Messenger that summer.
What about with one of Adam's accounts?
No, I think I was blocked.
All right, so Mr. Montgomery, I just have one other quick set of questions for you. And thank you for being patient with me today while I made sure that I was asking the correct questions of you. With regards to what you've talked about for us, one thing, and I'm sure you may be asked about this in a moment, so I'd like to save people some time now. Have you been convicted of 2 felonies out of this court within the last 10 years?
Yes.
And was one of those a conviction in 2015 for being a felon in possession of a weapon?
Yes.
And was one of those a conviction in 2016 for a theft by unauthorized taking?
Yes.
Okay. And from those, have you completed your sentence that was there, and those are all finished now at this point?
Yes.
Lastly, Mr. Montgomery, I'd like to show you State's Exhibit 97. Do you recognize this person?
I do.
And who is this?
It's Harmony.
I believe you said your recollection was that it may have been Harmony's left eye that you saw blackened.
I believe so.
Thank you. I have no further questions for you, Mr. Montgomery. Thank you very much for your time. I believe defense counsel may have a few after we speak with the court.
Counsel, please.
Good afternoon, Mr. Montgomery. Are you able to hear me okay?
Right now, yes.
Great. Let me know if you can. My name is Jamie Brooks, and I represent Adam, okay? I'll also ask you some questions, but I'll try to be fairly quick. You indicated that you returned to the Guilford Street address on the 22nd of July, 2019?
I believe I said the 22nd or the 23rd.
One or the other. Could have been the 22nd, could have been the 23rd.
Excuse me?
So it would be either the 22nd or the 23rd of July that you were there?
Correct.
And you ended up having a conversation with Adam. Correct?
Yes.
And this conversation included Adam, yourself, and Harmony in the kitchen, right?
Say that again?
The conversation took place in the kitchen?
Correct.
Harmony was there, right?
Yes.
You were there.
Yes.
Adam was there.
Correct. Yes.
Nobody else to your recollection was there.
No.
No other adult was within earshot of this conversation as far as you knew?
No.
And the conversation was prompted because you saw a black eye on Harmony.
Correct.
You indicated that Adam said that she didn't do anything.
Correct.
In response to your question of, oh my God, what happened? He said,
Oh my
Harmony
God,
didn't do
what the
anything?
fuck did you do? I think I said.
Okay. And as part of this conversation, Adam talked about finding Harmony suffocating Declan.
Hands over the mouth, I stated.
And with the hands over the mouth, Declan was turning blue.
Lips were blue,
Lips
is
were
what
blue.
I recollect.
5 months old at the time.
Declan, roughly something like that, yeah.
You said that he made a comment and sounded cocky?
Yes.
Also could have been sarcasm?
Not in my opinion, if that's what you're asking.
But he did express concern regarding Declan and the blue lips.
Yes.
You later made a report to DCYF.
Yes.
That report was approximately a week later.
Correct.
Would July 29th of 2022, I'm sorry, July 29 of 2019, would that sound correct to you?
Roughly about a weekish later, 7-8 days or something. Is that what? Yeah, approximate, I guess. It's going back a while.
Roughly 7 to 8 days, and this was after you had returned to Florida?
After I was back in
sorry,
New
back-
Hampshire, right? Is that what you're asking? After I came home?
Right. But
Yes.
You didn't go back to you didn't stay at the house except for that one night. Did you go back to Florida or did you go back to Massachusetts?
No, I went to Massachusetts.
Okay. Thank you, Mr. Montgomery. I don't have anything further.
Just briefly, please, Your Honor. Mr. Montgomery, about that. You just asked a moment ago whether, I think you were asked a moment ago with regards to Adam, you were asked a moment by Attorney Brooks about him sounding cocky and whether that might also be some sort of sarcasm. When he said, I bashed her all around the fucking house, did that sound like sarcasm to you?
No.
And when you asked Harmony, oh my God, what the fuck happened to you? Were you asking about her eye?
I did. I was.
At any point, did the defendant tell you that he had just jerked her away from Declan?
No.
And at any point when you were asked a moment ago on cross-examination about Declan's lips being blue, I want to make sure that's clear. That's not something that you saw, right? That's what the defendant told you had happened.
Yes, correct. That's what I was told.
From the defendant, that's what he says.
Correct.
Let me ask one last question with regards to your understanding. When Adam said that he bashed him all around the fucking house, do you feel that you have somehow conflated what Adam had said?
Conflated? Could you explain, please?
Confused one action for another? Do you think that Adam, when he
Say
said
that-
about, yes.
State it again,
So let me
please.
restate that. With regards to confusing one issue for another, or conflated what Adam had said, with regards to that, do you feel that you may have been mistaken that when he said that he bashed her all around the fucking house with regards to the black eye, that he was actually talking about just jerking her away from Declan?
I wasn't confused.
Thank you. No further questions.
Nothing further.
All right, you may step down.
Thank you.
Okay, ladies and gentlemen, it is just a little past 12:30, so this is a perfect time to break for lunch. I will remind you that you are not to discuss this case, not with each other or with anybody else. While I've indicated to you that you can check your phones on a break or during lunch, you cannot read any media. Make sure all your banners or notifications are turned off. You are not to view any media related to this case. Don't do any independent research. Don't look up any of the names that you've heard throughout this case. And I'll have you come back at 1:30 and we will resume evidence at that time. Please rise for the jurors, everyone. You may be seated.
Just to clarify, Mr. Montgomery is excused. States is not.
He may be excused if, any objection?
No objection.
Okay, yes, he's excused. With the understanding, Attorney Agati, that excused means he's not going to be called now or later.
Yes, Your Honor. In this instance, I think the state can agree.
Okay. So that is what I mean by excuse. So if we don't all agree that that's what excused means, then we should maybe revisit that after the lunch break, or so that everybody can take a look at it. Okay. Did we need to address any other matters now?
I think, Your Honor, just after the break, we might want to address that one thing with regards to Michelle Raftery, excuse me. But other than that, no defense counsel.
You mean Michelle Raftery?
Michelle Raftery. I apologize. I think other than that, Your Honor, the other things can certainly wait until after the break. There's nothing right now that we.
Okay, I just don't want to. I guess I want to know what we're going to talk about so that we can make sure we're starting on time with them. So if we want to have some legal arguments about something, let's talk about what that will be, and then I can tell you when you should come back so that we can do that rather than holding them.
If we can just have a look at this.
Sure.
that we should probably need to come back and discuss. One is with regards to Michelle Rafferty's ability to sit in on the rest of the trial. The state feels that she is entitled to do that under the Victims' Bill of Rights, specifically RSA 21-M:(K-8. She is considered to be a family member, and so as a result, she has that right to do that, even though she has been a witness. And even though she may be a witness, depending on what the defendant puts forward in their case in chief, if they choose to present, or he chooses to present. So I would say that's issue number one that we would have to discuss. Issue number two is, at this point, based upon the defendant's representations with regard to Anthony Badero and his behavior as alleged, Mr. Badero, I believe, already has counsel for a different matter, but we should probably set some time aside to have a very quick Richards hearing, because we do anticipate that Mr. Badero is going to be called as a witness in this case.
Wait, do you have any sense of when you might call him? I mean,
Not this week, Your Honor, I can say that, certainly not tomorrow. So I believe it would not be until next week. With regards to his specific time, I would anticipate the early part of next week, Your Honor.
Okay, so I think we will reach out to his counsel and see about some availability, maybe either towards the end of the day or early in the morning, either later this, I guess later this week is tomorrow, so, or early next week. But that counsel is going to need some information about.
I believe she has a lot of information already.
But does she know about what this is?
Yes, Your Honor. So he is currently represented, he's not currently represented on this matter, but he is currently represented by Attorney Ashley Sheehan.
Yes.
And so as a result, before we went to be able to subpoena him and be able to speak with him as part of the witness prep, we informed her. And so with that, I know that she is up to speed with regards to the issues that may be here. Not necessarily
But the
what
issue
this issue.
well, okay, but that's the
That we
issue.
have to get
So I
up to
think,
speed on.
so why don't we do this then? Rather than have the court contact her, the clerk's office, why don't I suggest, you tell me if you disagree with this, why don't I suggest that the state contact her to get to, the defense and the state can talk about what the issue is so that she's apprised. Find out her availability. She's going to need to be in touch with the witness, and then everybody would be here. We could do it before court on one, at 8:30 on one of the mornings.
I can tell you, I think she'll be able to do that in short order. It's our understanding that she was intending to be in the courtroom when he was testifying anyway.
Okay.
This particular matter, so we should be able to get that in short order.
Okay, so the sooner you can let us know, we can all, talk about the scheduling of this. And then we'll either do it before we start at 9. One of the Fridays I know is it this Friday? All right, well, during the break, I'm going to take a look. I know I have a short docket tomorrow morning at 9, so we won't start this at 9. I'll see if we can start at 9:30, but it might be 10. So maybe seeing about Monday morning. I don't know what you all think about that.
Certainly.
If not then.
We can move this testimony to a little bit later if we had to.
Okay. Okay.
The last issue, I'm going to go ahead and let Attorney Knowles address, considering that specifically that Dimitrios Saros is going to be one of the state's witnesses who's going to be called today, and it's with regards to statements that defense counsel made in the
Your Honor, I will say that the state, in listing witnesses that were going to be called today, did not mention Mr. Saros.
I'm sure he's right on the slip. I gave you guys that sticky.
He was. he was not, but we will figure out a way to deal.
All right, well, he can look for the paper but either way, it sounds like we're going to be able to continue the testimony. So what is the issue that you wanted to raise? And is this as to this afternoon's witness?
It is.
Okay, go ahead.
Again, Your Honor, I believe it was on the sticky note we provided to the defense.
Okay.
That said, Your Honor, excuse me. I apologize.
It's okay.
In opening statements, defense opening statements, the defense mentioned an opinion offered by this witness as to his findings regarding any abuse or neglect that occurred regarding the call that we just heard about from the last witness. Excuse me. And it's the state's position that opened the door to the basis of that opinion. The state being able to challenge the basis, the information that witness had regarding the abuse, regarding the investigation, information that he received prior to authoring that opinion, the witnesses that he spoke with, the information that he learned from them, as well as his observations, who was present when he interviewed the child. Again, that information was offered by the attorney at opening.
Basically, what they said was that he would say that he did not notice. What was it that you said? I can go back and look. But
it was both that he did not notice that essentially that the report was unsubstantiated, which is the terminology that DCYF uses in closing a report. That it's either substantiated or unsubstantiated. And
so
it was offered to the jury that the report was unsubstantiated. And I would just say, Your Honor, this would be the equivalent of asking an officer who testifies their ultimate opinion of guilt or innocence of the defendant. And so under 703, the rule on expert testimony, when such an opinion is offered, an expert opinion, which was unnoticed to the state can then, or the person that's challenging that evidence, so not the moving party or the proponent of that evidence, but the other party can then challenge that evidence, and inadmissible, what would otherwise be admissible, becomes relevant and admissible once that opinion is offered. And that opinion was given to the jurors. And I would argue that bell cannot be unrung, and that we get to challenge that opinion.
And what is it that you want to say? So what is it that you want to get into then?
The statements that he was provided by the statements that he was provided that led to his investigation, the statements, the witnesses that he spoke to, what he was told, what he reviewed.
So you want to get into the whole investigation that led to the determination that it was unsubstantiated.
That's correct, Your Honor.
Okay, let me see what the defense has to say, and then I may have some more questions. Go ahead.
Sure. So the 703, it's not applicable, Your Honor. This is not expert testimony. We're talking about a factual finding, or a lack of a factual finding, rather, made by a fact-gathering witness. So this is no expert opinion.
But whether expert or not expert, I guess the question then becomes, if you're going to ask him, you deemed this unsubstantiated, why could they not talk about all of the information that went into the ultimate conclusion?
Well, I think that perhaps they could, but as long as also it allows for Harmony's own words to be used and what she said, and the circumstances surrounding her being interviewed alone. There can't be cherry picking.
Well, although you're basically, you put in information that then leads them to open the door to the information that you actually want to get in. That seems a little suspect, Attorney Brooks, no? In fact, I'll look, but I think there's some law on you opening the door for the purposes of getting in otherwise.
I'm not opening my own door, Your Honor. I'm not allowed to do that. But the state, in turn, shouldn't be able to just selectively pick various things. And I have no idea at this point what they would be seeking to introduce. Perhaps we can have a discussion about that during the break. But this is not a 703 or an expert situation. 703 is inapplicable. Again,
It does feel that it leaves the jury with a misleading impression if you just get to say, he reported, Kevin Montgomery reported this to you and ultimately you deemed it unsubstantiated. And that is my concern. So, and then it does seem that your expectation would be that they would then get to put in the other parts of that, the rest of the investigation, which would include the statements that you would like to get in, which would be Harmony's statements. I mean, isn't that sort of the natural?
Yeah, I'm not sure if the state is seeking to get in. I'm not sure what from the DCYF investigation they're seeking to get in, or the limitations of that investigation, or the fact that there may have been subsequent information that Saros did not have. I don't know.
Let me ask you, Attorney Knowles, what are you trying to get into?
The substance of the investigation.
I know, but what is the substance beyond that Harmony had said that? Because what you don't. Well, let me start here. If I let you get into what you want to get into, and then the state says, well, if you say that, then we want to get into Harmony's statements. Is that acceptable to you, that it just all comes in, everything about the investigation? Sure.
Your Honor, the state's fine with getting into Harmony's statement, but understanding that that statement was not made alone. This was just represented. She wasn't alone when that statement was made.
And the balance of the information that you want to admit with respect to the defense having said that it was unsubstantiated is what?
The substance of the statement that the caseworker received in responding to the call and initiating the investigation, what he did with that information.
But can you just tell me what it is?
Oh yeah.
Okay.
Yes. Sorry.
I'm just trying to understand where we're going with this, so we don't end up in the middle of trial. So
right.
Go ahead.
So it's Kevin Montgomery's call, his repeated calls to DCYF.
And the substance of those calls, or just that he's?
Of those calls.
Okay.
And I would admit those through the witness.
Okay, so the substance of those calls being what? Tell me, walk me through what you want to admit here. And I'll give you a chance to respond. I'm just trying to get the lay of the land here. You all have this discovery. I don't have this.
So I'm looking at Bates 2084.
Yep.
Reporter is hard to follow and understand. Reporter said that he came back from Florida on Monday, July 22nd, 2019. And his 4-year-old niece had a shiner from her 29-year-old father. Reporter said that the reasons for the shiner was that the father gave an ass whooping because the 4-year-old had been left alone with the 2-month-old, the 6-month-old, while the father was in the bathroom. Reporter heard from her niece and nephew that the baby had been crying, screaming, so the 4-year-old had to put a hand over the 2-month-old's mouth. Father said that the 4-year-old did this very tight and very hard. Father said that he had beaten the dog shit out of her. When reporter left for Florida, there was one running water in the home, and now the electric had been shut off. And I'm just reading the statement.
Okay, basically, you just want to get in. You want to get in the rest of Kevin Montgomery's statement.
Correct. I want to get into the rest of his statements, but I also want to get
You had Kevin Montgomery on the stand, so I'm
right.
So I'm not sure why we're having this conversation.
So, Judge.
Yeah.
Again, the defense rung this bell. They opened the door under the opening the door doctrine, which I believe I've briefed for this court previously. It makes evidence that would otherwise be inadmissible, hearsay, relevance, admissible. Our argument is that evidence, those statements, in addition to what Demetrios, the witness who will testify, did with those statements, what he did with the information, or what he didn't do, that now becomes admissible. It allows
Why
us.
was that, though, what you just read to me, not admissible through Kevin Montgomery, who you had on the stand?
It's offered for another purpose, to challenge that witness's opinion that was offered to the jury. To say, this is the information that you received. Let's talk about what you.
So you essentially, okay, now I think I'm understanding maybe better. You want to undermine the fact that he came to an opinion that this was unsubstantiated by using, just strengthening the statements made by Kevin Montgomery to him. So you want to basically say, he told you all of these things and you still found it unsubstantiated.
Contacted you on this date, on this date.
Okay.
And, okay.
Yes. And what he did with that information, Your Honor.
And what did he do with that information?
I think the evidence would be that he did nothing with that information, Judge. He contacted the police and told them it was a non-issue without seeing the child.
Okay, so
when he saw the child, he saw an injury to the child, which was also discussed to the jurors, and he still found it unsubstantiated. Investigating.
Okay, so why? So putting aside, the Kevin Montgomery's additional statements, do we all agree that Mr. Soros could testify? You were. It's my understanding. It's your plan to elicit that ultimately he made a finding that the report was unsubstantiated. And then the state is going to say, so even though, this Mr. Kevin Montgomery contacted you and told you all of these things, you didn't follow up, that's right. You didn't do anything further, that's right. And ultimately you came to that conclusion that's unsubstantiated. We can all agree that that's admissible so far, right?
Yeah.
Okay. Go ahead.
Just to be clear, though, and I don't think the state is suggesting this, but just so there's no misunderstanding, Mr. Montgomery
Kevin Montgomery, yeah.
made a lot of phone calls, continued on and on and on for months into, I think, 2000.
Okay.
After Harmony was even gone, making all kinds of sets of allegations. Obviously, that would not be coming in. The door isn't open to everything or anything. And also tangential to the concern about the black eye, which was reported on the 29th, there was also think about a spoon or potential drug activity. And obviously that is not something that should be allowed to get into.
Okay. So let's put aside the drug information for a moment. It sounds like we are not in disagreement, except that the statements by Kevin Montgomery, I mean, you can say, now you got a call from Mr. Kevin Montgomery, and he contacted you, and he informed you that he was aware of this abuse, and then what did you do? And you can follow up, because it's your view that it's what he didn't do that undermines the defense view that this is unsubstantiated and therefore did not occur. So I think that is admissible. But I don't know about all of the hearsay statements from a witness you just put on the stand and didn't elicit the additional statements from. I'm not convinced about that.
Well then, Judge, I would move to strike. I move to admonish the defense for making that statement to the jury.
No. Take a minute, yes.
Your Honor, the state seeks to challenge the basis of the opinion that was offered to the jury. The basis including what this witness was told by Kevin Montgomery, what he did with that information. So challenging the basis of what he was told. And I would note that that includes drug use. That was part of the report. It wasn't just the black eye, it was drug use. And when the witness went to the home, he saw evidence of drug use. He saw drug paraphernalia, and still he found that the report was unfounded. So it's the basis, the foundation of his report, the foundation of the opinion that he gave, that the abuse was unsubstantiated, that this claim, and this is a specific claim which was unfounded. It's report number 826330, which includes claims of the abuse, claims of drug use.
Okay. So I think what they're trying to do is just, they're trying to argue if you put in the information that it was deemed unsubstantiated, they can challenge that, the basis for that finding. Do you have any objections?
Sure, but I think the context of the opening statement was very clear about what there was not evidence of. So if I'm hearing the state correctly, they are seeking to introduce evidence about drug use.
Yes. They are, what they are arguing is that if you cross-examine that witness to say, you did an investigation and you found that it was unsubstantiated, that they get to challenge that. That is that, and basically undermine his opinion to say you found it unsubstantiated, even though you found abuse and neglect unsubstantiated, even though there was evidence of drug use in the house, even though there were several reports. There was this report of a black eye, and you didn't go to the house, you didn't do X, Y, and Z. That's what they want to do if you are going to bring in the evidence that it is unsubstantiated.
Okay. Fair enough. I can certainly not use that word, but I think at the same time I should be able to elicit the facts, the observations that he saw and did not see with regard to the state's second-degree assault charge. He was there to investigate that.
Okay. So then I'm thinking that what you are going to want is some kind of curative instruction about the finding that it was unsubstantiated if now the defense is not intending to go down that road. And I really need to give the staff a break, so we're going to...
We could discuss that maybe over the break.
Is he going to be the first witness that you're going to call?
He's not going to be the very first witness, Your Honor, that will go on. Just thinking briefly, he's going to be a third witness that we call.
Okay, so maybe we may have a little bit of time in the mid-afternoon break, but I am going to, I do want to have us come to some conclusion about this beforehand. So
if I can just clarify, Your Honor, from our perspective. So with regards to if the defendant is intending to ask about his findings, and then what his observations are, certainly relative to those findings, then the state is seeking to ask about what his other observations were and what he did or did not do before he reached those findings. And our position is that those findings have already been talked about now in opening argument, with the implication that the conclusion was made that this was unfounded. So in essence, the door has been opened, the bell has been rung, that there is a finding out there that this event was unfounded, despite what Kevin Montgomery just testified to, or the work that was done. If that's there, and if we're going to be talking about the findings and what did Mr. Saros do, then the state should be able to ask also what else did Mr. Saros know, and what else did he do and not do. So it's
what do you mean? What did he know in terms of that investigation? Right?
Yes.
Okay.
Not in terms
okay.
of
I just want to make sure we are just talking about this investigation. Okay. And then, so there's basically two questions on the table. If they go down the road to challenge Mr. Soros's findings in any way, it is your view that you want to talk about what did he know in coming to those findings and what did he do or not do in coming to those findings only as it relates to that particular investigation. And if the defense is now saying, maybe we don't want to go down that road, then we've got to talk about, I understand it's your view that they rang the bell and in any event you get to do all of it.
And I'm not yet convinced, so I guess Attorney Brooks, you're going to have to make a very, very clear decision about that.
Oh, and I think the decision will be clear.
What if you have the decision?
Sure, I'm not going to ask for if he made a specific finding as part of his obligation as a DCYF person.
Then you need to be thinking about the issue about a curative instruction if I don't say that you've already opened the door to it. Okay? So we're going to go off the record now.
Okay.
Because I do want the staff to take a break. If you want to say something to me off the record, I will listen to it, but then we can put it on the record, but otherwise we're going to think about where we are. Okay? All right. Thank you, everybody.
deal with, and we could still be able to start at 9.
Oh.
Okay, so I'm gonna confirm that, but that's my hope.
We'll be here.
Jury.
Please be seated. State may call its next witness.
Your Honor, the state calls Katie Moore to the stand. Swear that the testimony that you're about to give will be the truth and the truth and the whole truth under the pains and penalties of perjury.
I do.
Okay, you can have a seat, make yourself comfortable. And there's a microphone right in front of you. Just make sure that you're talking into that. Can you start by stating and spelling your full name for the record?
Katie, Katie, Morin, Morin.
And what's your date of birth, Ms. Morin?
6/10/78.
What city and state do you currently reside in?
Laconia, New Hampshire.
And how long have you lived in Laconia?
About 3 years.
How are you presently employed?
I work in retail.
In retail? And how long have you done that? How long have you worked in retail?
My whole life, about 20 years, probably.
And what's your highest level of education, Miss Morin?
GED.
Do you know someone named Adam Montgomery?
Yes, I do.
And can you tell these jurors how you know Adam Montgomery?
We were in a rehab facility together, and then we became romantically involved for a little bit.
What year would that have been in that you were romantically involved with the defendant, Adam Montgomery?
2021.
And, Your Honor, may I?
Yes.
And Your Honor, I'm showing the witness what's been published as State's Exhibit 101. Ms. Moore, do you recognize?
Yes, I do.
The individual that's there?
Yes, I do.
And who is that individual?
It's Adam Montgomery.
That was the individual that you were romantically involved with in 2021?
Yes.
Were you aware of whether or not the defendant was married at that time?
I was.
And did he ever tell you anything about his wife?
Not just that they hadn't seen each other in a while.
Do you remember providing a statement to an officer with the Manchester Police Department back in February of 2022?
I do.
And that statement was regarding the defendant, is that right?
It was.
Do you think that seeing that statement would refresh your recollection of what the defendant may have said to you about his spouse, about his wife?
No, I recall.
Okay. And what do you recall him saying about his wife?
That she would do anything for him.
That she would do anything for him? During the time that you were romantically involved with the defendant, did he ever discuss his children?
He did.
So you were aware that he had children?
I was.
Was there a particular discussion with the defendant that stood out to you about
Yes.
the children? And
Yeah.
tell us about that.
We were at lunch one day and just talking about our children in general, and he stated that the worst thing that had ever happened or he had done was he walked out of the bathroom and Harmony was suffocating the baby. So he backhanded her as a, I don't know if it was as a reaction is the way it was told to me, to stop her from suffocating.
So he said he backhanded her.
Yes.
Did he say what the result of that backhand was?
He said he hit her glasses, so she ended up with a black eye.
Did he describe anything about that black eye that you just mentioned?
No.
In that conversation where he discussed causing that black eye, did he say that he had nudged Harmony out of the way?
I don't recall.
He said he backhanded her.
I don't recall his exact verbiage.
Did he ever discuss other children with you?
Yes.
And what were those discussions? What was the substance of those discussions?
He's told me that he had 5 children, all under the age of 7. They all had the same mom. At one point, I asked him to go to Maine with me when I was leaving, and he said he would be too far away from his kids, so he could not.
If I could have just a moment. Thank you, Ms. Moore. No additional questions.
No questions, Your Honor.
All right, you may step down.
Thank you.
State may close. Next witness.
Your Honor, the state calls Nicholas Ahern. Mr. Ahern, if you can just remain standing and raise your right hand. Do you swear that the testimony that you're going to provide this jury will be the truth and the whole truth under the pains and penalties of perjury?
Yes.
You can have a seat and make yourself comfortable. Mr. Ahern, can you start by stating and spelling your full name for the record?
Yes, it's Nicholas Ahern, Nicholas. Ahern, Ahern.
Thank you. And Mr. Ahern, what city and state do you live in?
Manchester, New Hampshire.
How long have you lived in Manchester?
My entire life.
How old are you?
34.
Mr. Ahern, what do you do for a living?
I do construction, metal framing, drywall.
Framing and drywall?
Yep.
How long have you done that?
Since I was like 20.
It's 14 years?
Yeah, a long time.
What's the highest level of education you've obtained?
I think it was 11th grade.
And did you get your GED?
No, I went right into the trade.
Do you know someone named Adam Montgomery, Mr. Ahern?
Yes, I do.
Yes.
Mr. Ahern, I'm showing you what's been published as State's Exhibit 101.
Yes.
Do you recognize that individual?
Yes, that's Adam Montgomery.
And how long have you known Mr. Montgomery?
I want to say since I was like 18. So, yeah, a long time.
Are you aware of him having any children?
Yeah, I know he has a couple.
Are you aware of a daughter?
Yes. Yes.
Have you ever seen his daughter?
Yes, once.
Do you know her name?
Harmony.
What can you tell us about that one time that you saw Harmony?
She came out of the house and she had marks on her face, which was a black eye.
Okay, and so let's unpack that a little bit. When you say she came out of the house, what house did she come out of?
I think it was Guilford Street, yeah.
Is that the house that she lived in? Was that your understanding?
Yes, that's where they lived.
So were you visiting the defendant when you saw Harmony?
Yes.
And what were you doing when Harmony came out of the house?
Just sitting out front talking to Adam.
What time of year was this?
Summertime, I want to say around July.
Do you remember what year?
I think it was 2019.
And let's talk about that injury that you saw. What can you tell the jury about it?
It was a pretty severe injury. At the time, I questioned Adam, what happened, and he told me that she acquired it during a soccer accident. Yeah.
When you say severe injury, what did you see? Can you explain to this jury what made it severe in your opinion?
Her eyes were blackened. Yeah, it was pretty intense in the moment. Yeah.
Was it concerning to you?
It was, but he told me that she acquired it during a soccer accident. I have kids, so I understand, accidents happen. So.
Do you know someone named Kevin Montgomery?
Yes.
At some point after you saw that injury to Harmony, did you have a conversation with Kevin?
Yes, he contacted me.
And I'm not asking you for the substance, just whether or not.
Yes.
And you said he contacted you, is that right?
Yes.
When Harmony came out of the house, about how long did you see her for?
Maybe 4 seconds. It was quick.
Why was it quick?
Because he told her to go back inside.
And sorry, when you say he told her to go back inside.
Sorry, Adam Montgomery told her to go back inside.
Can you tell the jury how he told her to get back inside?
He was, Adam was forcive. He just, basically told her to go in, and he kind of walked her up to the door and shut it.
About how old was Harmony when you saw her that day?
I want to say maybe 5, something like that. 5.
How would you describe her when you saw her come out for those 4 seconds?
She was just standing there, just looking. No real body movement, just standing there.
And when the defendant forcefully told her to go back inside, did she obey?
Yes.
If I could have just a moment.
Yes.
Thank you, Mr. No additional questions, Your Honor.
Counsel?
No questions, Your Honor.
You may step down.
And we'd ask that this witness be excused, Your Honor.
Any objection?
No.
Right, you may be excused.
Your Honor, at this time, the state would call Deputy Sheriff Paul Mott. Sorry, just a moment, Your Honor. you like me to just check in the hallway?
Sure.
I'll set you on. Deputy Sheriff Paul Montgomery.
Careful with the wires, please.
Deputy, if you just please remain standing when you get there for a brief moment. Thank you. Please raise your right hand. Do you solemnly swear that the testimony that you will give this jury will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please feel free to have a seat. And Deputy, as we're being recorded here today for the record, would you please go ahead, state your full name and spell both your first and your last name for us?
Paul Montgomery, Paulmontgomery.
Okay. And I bet I already know the answer, but where are you currently employed, sir?
Hillsborough County Sheriff's Office.
Okay. How long have you worked for them?
7 years.
7 years so far. Okay. And with regards to your employment with them, did you ever work in any other sort of law enforcement before working for the Sheriff's Office?
I started in New York City in 1985, NYPD.
Whereabouts in the city?
Lower Manhattan and Brooklyn.
Okay. How long were you there?
5 years.
5 years, okay. And after that, any other sort of law enforcement
Town
experience?
of Henniker for 5 years.
Okay.
Merrimack County Sheriff's Office for 20. State for 2. And now I'm here part-time.
And when you say state for 2, what agency did you work for those 2 years?
Patrol DMV.
Okay. And what were some of your day-to-day duties for them?
We basically dealt with trucks and inspection stations.
All right. So with regards to your duties now for the Hillsborough County Sheriffs, you said you're working for them part-time, is that correct?
Yes.
All right. So what are your day-to-day duties? What do they look like?
Primarily transporting prisoners to and from the jail and the prison.
Okay.
To the courts.
And let me ask you, do you ever, let's say, when did you come back to do part-time again?
2019.
2019, okay. I want to specifically draw your attention to November 27th of 2019. And on that particular day, I'd like to ask...
2017, sorry.
2017 is when you
I
came
went
back.
to, yes,
Okay,
Hillsborough County.
that's all right. Let me be specific, though. Let me steer you to one day in 2019, just before Thanksgiving, November 27th, 2019. Did you help serve or were you present for an eviction notice at 77 Guilford Street in Manchester that day?
I was.
Okay. And I wondered if you could explain a little bit for the jurors, just for an eviction process, what is the role of the deputy sheriff? What are you there to do?
So we have a court order that's evicting whoever's there on the premises. I was a second deputy. I'm assisting the primary deputy. Usually we send 2 guys. And for some reason, I don't know what, his partner was tied up with something else, so they sent me over. And I just assisted with posting the property and having the people leave.
And typically, how long does this process take to do an eviction? Just typically in your experience, I mean.
We usually give them 10 to 15 minutes to get some belongings and skedaddle.
Okay. And on this particular one at Guilford Street, do you have any recollection of roughly how long that took?
Probably 10 to 15 minutes, the ordinary time.
Was there anything about that eviction that necessarily stands out to you, or was it just a very typical eviction for you?
Pretty much the same as all others. Okay. There were a lot of clothes around. It was kind of dirty. And there were a couple children there. And there was a male and a female.
Okay. And when you say male and female, and you say male, female, and children, so the male and the female, are they both adults?
Adults, yes.
Okay. And then the children, do you remember how many there were?
I couldn't tell you for sure.
Okay.
There were a couple. I would say at least 2, but I can't tell you if there was any more than that.
Okay. Where did they go at the end of the eviction?
They got into their vehicle and they left.
Okay. And with regards to the home, what happens to home when an eviction takes place?
So we post it with no trespass stickers.
Mhm.
And usually the landlord will come and change the locks.
Okay.
I don't recall if there was a landlord there that day. Sometimes they don't show up, and we just post it.
And I just want to make sure that I understand on this particular one. I believe you said before when you do an evictions, it's based upon an order from the court. Is that right? All right. Do you have a copy of that order when you go to do the eviction?
We do.
Okay.
I did not personally have that. That would have been my partner that had the paperwork.
Sorry, I need to be near the mic. Is that a routine practice of being a let me try this in English. Is that a routine practice of the sheriff's office to make sure that a copy of that order is in hand before the eviction is done?
In our hand, yes.
In your hand?
Yes.
Okay. And do you have any reason to believe that's not what happened that day?
Not at all.
Just a moment, please, Your Honor. Thank you very much, Deputy. I don't have any further questions for you. Defense counsel may have a couple.
Okay.
No questions, thank you.
All right. You may sit down.
Thank you, Ron.
Statement call its next witness. Yes. Sometimes things go more quickly than we think. Oftentimes they go more slowly than we think, but sometimes they do go more quickly than we anticipate. This is one of those times. So what I'm going to do is I'm going to have you take a break as soon as the next witness is ready, and we're ready to take their testimony. We will call you back in. We hope that will be in the next 10 to 15 minutes. All right? So same rules apply, not to talk about the evidence, not with each other or with anybody else. Don't do any independent research, and we will call you back in as soon as we can. Thank you, ladies and gentlemen. All right, so counsel, are we going to need still to have you speak to that witness before we are able to take the witness?
We should let the both sets of counsel should be able to ask that question. So we know where we're going from there. I imagine probably be best practice for us to come in and report to you what that answer is so that we can have you answer on which way to proceed.
I think it'll be a quick process.
That's fine. That's fine. That's fine. I'm just thinking that while we are in that waiting posture, is there anything we can accomplish so that you know which question you just need to ask? The only question is whether someone else was there. Do you want to approach for just a minute?
Yes, sir. I have to use just someone's here. So would you like us to approach right now, or would you like us to go get that answer and then approach?
Get the answers you need, and then I will wait, and I'll have the court monitor take a break until you're ready. You can take a break. No, you can go off the record.
Unless it's just one question and you want to come right back in. Why don't you go ask the question? We'll stay here. If you can stay on the record if you want to take a break. Feel free.
Say, we did have an opportunity to ask him with regards to that question of whether or not he spoke before. His, and Attorney Brooks can correct me if I'm wrong, but his statement is that he cannot recall. He said that typically there would be a practice to try to speak with a child alone, but that didn't always happen, or that a parent could either be nearby or him. So he doesn't have a recollection of whether he spoke before.
Okay, so he doesn't know. Okay. So where does that leave us with regard to, you're just, why don't I ask you, Attorney Brooks, we were talking about what you were going to ask, or the other way is just to proceed. I mean, as you know, as state's already indicated, they're going to be looking to challenge him to the extent that you try to get into any opinions, concerns, findings, any of that.
I don't plan on stepping there.
Okay.
I'm sorry, Your Honor.
That's okay.
We're all set.
Okay. Everybody thinks we have a good enough understanding of where things stand? Yes? All right.
Yes, ma'am.
All right, then let's bring in the jurors. All rise for the jury, please. Counsel, so after this witness, am I releasing them and having them come back at 8:45?
45, I anticipate a very full day.
Okay. Counsel, I'm sorry. Attorney Smith, did you hear that?
No.
After this witness, we'll be releasing them then for an 8:45 return tomorrow.
Yeah.
That's fine.
That's what I'm saying.
All rise for the jury.
Please be seated. The state may call its next witness.
Attorney, the state calls Demetrius Soros. And Mr. Soros, you can remain standing. Raise your right hand. Do you swear that the testimony that you're about to provide will be the truth and the whole truth under the pains and penalties of perjury?
I do.
You can make yourself comfortable. Can you start by providing, by stating and spelling your full name for the record?
Yes. My name is Demetrius Tsaros. First name is Demetrios. Last name is Tsaros.
And Mr. Soros, I'm just going to ask that you speak as loud as you can.
Yeah, thank you. I will.
Mr. Soros, what city do you live in?
I live in Concord, New Hampshire. I apologize. I just moved. Pembroke, New Hampshire.
How long have you been a New Hampshire resident?
All my life.
And what do you currently do for a living?
I am a career level letter carrier for the Postal Service.
The U.S. Postal Service?
Yes, yes.
And how long have you worked in that capacity?
Since September of 2021.
Prior to September 2021, how were you employed?
I was employed as a CPSW, a Child Protective Service worker with the state of New Hampshire for DCYF.
And that acronym that you just gave, CPSW, what is? Can you tell the jurors what that means?
Yes, Child Protective Service worker.
How long did you work for DCYF?
Approximately 10 years.
And in your capacity as a caseworker for DCYF, did you have occasion to interact with someone named Adam Montgomery?
I did.
And calling your attention specifically to 2019, the summer of 2019, did you receive a report regarding Adam Montgomery?
I did.
Are you aware of whether or not he had children?
Not when I first received the report.
Was the report regarding one of his children?
Yes.
Which child was that?
Specifically, it was Harmony.
Harmony Montgomery.
I'm sorry, Harmony Montgomery.
And was that report regarding an injury to Harmony Montgomery?
Yes.
Do you know who made that initial report?
I do not. It was anonymous.
Do you remember specifically when that report was made?
It was July of 2019, towards the end of the month. Specifically, it was either the 19th or the 29th.
Would looking at your report refresh your recollection?
Yes.
So showing the witness dates 2082.
Yes, July 29th, 2019.
Did that refresh your recollection?
Yes.
Okay, so if you could just turn that over. Let's face down.
And sir, I'm just going to ask you to keep your voice up so that all the jurors can hear you, okay?
Yes, ma'am.
Thank you.
And can you tell us that date again? I missed it.
July 29th, 2019.
And what did you do after your involvement on that call began?
I apologize. Could you be more specific?
So you got a report. What did you do after you received that report?
When I received the report, I initiated trying to make contact with the family in order to see them, see the family, see the children, ascertain safety.
And is that generally what you do, or is that what you did in this specific case?
Generally, that was the standard practice.
In this specific case, though, what did you do?
Specifically, tried to initiate contact. I ended up going out to the listed address in an effort to see the family.
Do you recall what that address was?
I believe it was 77 Guilford Street or Guilford Ave.
Tell us about that trip out to the 77 Guilford Street or Ave.
So I drove to the location, and as I pulled up, to the location, I noticed a person who I recognized as Adam Montgomery getting into a car.
And let me stop you there.
Yes.
Yes.
So, Mr. Soros, I'm going to show you what's been admitted and previously published. It's as states Exhibit 101.
Mm-hmm.
Do you recognize the individual that's depicted there?
I do. That's Adam Montgomery.
So, when you said that you recognized the individual getting into a car, I believe?
Yes,
That was this Adam Montgomery?
it was.
Was anyone else present with him as he was getting into that vehicle?
There was a young girl, small girl.
That interaction, your observation of the defendant, Adam Montgomery, and the small girl who was with him, how long was that?
Not very long. Basically, as I was pulling up and getting ready to park, they were getting into the vehicle, and I can't remember exactly how far away I was, 30, 40 feet or so, when I was parking my car, and I observed them getting into the vehicle.
So you're parking your vehicle. Were you outside of your vehicle when you saw him, or were you still inside your vehicle?
I was still inside my vehicle.
And this young girl that you saw with the defendant, what was she doing?
Nothing really in particular, just, getting into the vehicle, her father helping her into the vehicle. Excuse me. I didn't know if it was her father at the time. The person, Adam, helping her into the vehicle.
Specifically with respect to that small female that you saw, how long were you able to observe her for before she got into the vehicle?
Maybe 10 seconds, 15 seconds, not a long period of time.
And this was from 30 to 40 feet away?
Correct.
I want to back up for just a moment. The child that you were going to see, it was a female, is that right?
Yes.
How long, sorry, let me strike that. Were you able to clearly see the child when you were in your car there?
I guess as clearly as I could from that distance.
Did you observe anything about the child other than her gender?
No, just
It literally just looked like a small child, a female, getting into a car with someone.
How long were they parked there for before they drove away?
Not long. She got into the car. He then got into the car, and they drove away.
And you said the distance already, but was this on a public road, or were they in a driveway or something else?
Public road. They were parked on the side of the road in front of the house that I was going to.
During that home visit, did you interact with a child named Harmony Montgomery?
No.
Why not?
Aside from seeing her. At that home visit, because she had left. She was the little girl that got into the car.
Is that something that you learned that day or at a later time?
That day.
While you were at the home attempting to make contact with Harmony, was there anything that drew your attention away as you were approaching the home?
Anything that drew my attention away?
Yes.
Nothing in particular.
Do you recall?
Sorry, go ahead.
Do you recall noting that there was a loud dog that was barking at you?
Yes. There was a loud dog, a large dog, barking at me from the property.
And was that before or after the defendant drove away with this young female?
I believe it was after. It was after they left. I approached the property.
So you were unsuccessful in seeing Harmony Montgomery that day?
Correct.
Did you attempt to follow up with the defendant?
I did.
Tell us about those attempts.
That was initiating a phone call and speaking with Adam and trying to arrange a home visit in which I could actually come and see and speak with Harmony.
When were those attempts? You mentioned a phone call. When was that phone call?
I think I would have to look at my notes to refresh my memory, but I believe it was later that day that I spoke with Adam on the phone.
Please do, if you believe that that would refresh your recollection.
Yes, it was later that day.
Did you also attempt to call the defendant on August 1st?
I again would have to refer to my notes.
Please do.
I did.
Did you speak to the defendant on August 1st?
I did.
What, if anything, did he tell you about Harmony's condition?
I would have to, again, look at my notes for details.
Please do. And just look up when your memory's been refreshed. Do you recall what, if anything, the defendant told you about Harmony's condition when you spoke to him on August 1st?
The contact I just reviewed, I was speaking to him about setting up the home visit and that he had, one of his children was not feeling well and he needed to take him to be seen.
And
So I'm sorry.
Go ahead.
So we would not be able to have a home visit and it would have to be rescheduled.
And during that conversation, did he also tell you that he believed that Harmony had the same illness as his other child?
That I don't remember. I don't recall.
Do you think that reviewing your notes would refresh your recollection?
Yes.
Please do. And Mr. Soros, is your memory refreshed?
Yes, and Adam did say that he believed Harmony now had the same illness or condition that his other child had.
That again was on August 1st.
Yes.
So 2 days after you went out?
Correct.
At any point during your response, did you have a face-to-face with Harmony Montgomery?
Could you ask me that again? I'm sorry.
At any point during your response, did you have a face-to-face interaction with Harmony Montgomery?
My response as far as my following up with the report.
Correct.
I did.
When was that?
I believe it was about a week later. The exact date, I don't remember.
Do you think that reviewing your report would refresh your recollection with respect to the date?
Yes.
Can you please do so?
Yes, it was August 7th, approximately a week later.
What, if anything, did you observe about Harmony's physical appearance when you saw her on August 7th?
Overall, excuse me, overall, she seemed...
So let me strike that question.
Yes.
Specifically, did you notice any markings or injury to her face?
I did notice a small red mark under one of her eyes and some redness with discoloration in the eye that was closest to that.
Did the defendant tell you anything regarding how that injury occurred?
He did. He said that he had bought the kids, he had 2 younger children, he bought the kids like foam swords or lightsabers, and that they were playing with them, and that Harmony was struck in the face, in the eye, and that's how she got that mark.
So, Mr. Soros, I want to switch gears, and I want to discuss January of 2020. On January 8th of 2020, did you make contact with the defendant?
I believe so. I would like to review my contacts, please.
I'm sorry, could you speak a little more loudly?
Yes, ma'am.
And repeat the answer to that question?
I do remember receiving a report then, and I don't remember the exact date and whether I made contact or not.
Would it refresh your recollection to look at your report?
Yes. If may I?
In just a moment,
Yeah.
So feel free to review that and just look up when your memory can refresh.
Yes, it was January 8th, 2020.
And how did that communication occur?
I apologize, meaning how did I contact them?
Yes.
Oh, phone.
You spoke to him on the phone?
Yes.
And what, if anything, during that conversation did he say about Harmony Montgomery?
I believe it was that conversation. I would have to check my notes to make sure because I can't remember if it was that conversation or later when meeting with him that he had told me that Harmony was now living with her biological mother.
Do you recall the specifics of what he said about how she came to be with her biological mother?
He had said that she was having visits with her mother, and again, I'd have to probably look at my notes again, but I believe due to their unstable housing situation that Harmony ended up staying with her mom.
Did you follow up with Crystal Sorey?
I did make an attempt. I called, and I believe I left a voicemail.
If I could have just a moment, Mr. Thank you, Mr. Smith. No further questions, Your Honor.
All right, thank you. Attorney Brooks?
Good afternoon, Mr. Saros. We met briefly beforehand. My name is Jamie Brooks. I represent Mr. Montgomery. Just in terms of the timeline, a report came in on July 29th of 2019 regarding Harmony, correct?
Correct.
And specifically, it was that Adam had caused a black eye.
That was in the report. Someone referred, whomever it was that made the report referred to it as a shiner, which I interpret as a black eye.
And the report was made anonymously, but you knew the person to be Kevin Montgomery?
I did learn that later on.
So that day you went to the residence, the 29th.
Yes.
But it was a very fleeting encounter. Adam and Harmony were getting in a vehicle as you were arriving.
Correct.
So you observed Harmony for all of 10 seconds, right?
Thereabouts, yeah.
30, 40 feet away.
Mm-hmm.
You were in your car still at the time.
Yes.
But you did have a longer visit approximately a week later, correct?
Yes.
That was August 7th?
Yes.
You went inside the residence?
I did.
And it sounds like you spoke with Adam, but you also spoke with Harmony.
I did.
Your general or preferred practice is to try and meet with the kid alone, correct?
Correct.
But that doesn't always happen.
Correct.
Sometimes there is a parent there.
Sometimes there's a parent there.
Or in the next room.
Or in the next room.
And you don't have any specific recollection regarding whether anybody was present when you spoke with Harmony.
I don't recall that.
But you were able to visually see Harmony, right?
Yes.
And you noticed a little bit of red in her right eye?
I can't remember if it was a right or left eye, but it was one of the eyes.
In one eye. There was some redness?
Yes.
Faded bruising as well?
Yeah, I'd refer to it as like a faint red mark and then some redness in the eye.
Harmony had her glasses, right?
She did.
She agreed to remove them, right?
Yes.
So that you could look at her.
Yes.
And there's a standard set of questions you ask under these circumstances, right?
I do. I did.
So again, without indicating what the answer was, you would obviously ask her what had happened.
Yes.
And other questions regarding her general safety.
Yes.
Aside from the redness in her eye and the faded bruising, you did not observe anything else concerning regarding Harmony's person or well-being?
I did not.
I don't have any further questions. Thank you.
Just one question for you, Mr. Soros. So if I understand correctly, you're not sure whether when you spoke with Harmony, if her father was in the room, in another room, or somewhere else?
Correct. I don't recall that.
Thank you.
Nothing further, Judge.
All right, you may step down.
Thank you.
Your Honor, may this witness be excused?
Any objection? All right, this witness may be excused. Okay, ladies and gentlemen,
As I said, things moved a little more quickly than the parties anticipated today. So we are going to end a little bit earlier today. It's our hope that we're going to go through with a full day tomorrow. So plan accordingly. Get a little. Looks like maybe there's a little bit of nice weather this afternoon, so so you'll get a little additional time. But I'll have you come back at 8:45 tomorrow, with the hope that we will get started on time at 9 a.m. Okay, so please be back at 8:45 tomorrow. Once again, don't discuss the case, not with anybody, not with each other or with anybody else. Don't do any independent research. Don't drive by the locations. You know, if you happen to drive anywhere along the route we were in the other day, yesterday, don't pay any additional attention that you wouldn't ordinarily pay if you were just on your direct route home, okay? Once again, I do anticipate that there is media regarding this case. So turn off all the notifications on your phone. Don't look at the newspaper or the local news, please. Maybe focus on international news if that's what you want to do, but please make sure that you are avoiding any newspaper, online, or other media coverage of this case as we continue the trial. All right? Thank you so much, ladies and gentlemen. We will see you tomorrow morning.
All rise for the jury.
Be seated. This is, I guess, a good time for us to take up any housekeeping matters if we have any, in the hopes that, and I don't know, maybe as you look at the witness lists.
I believe the state understands that tonight we'll be trying to get a hold of Attorney Sheehan in regards to that question on Mr. Rivera. Mr. Rivera not involved in this case.
Okay.
If I can just brief on it.
Absolutely.